All right, we'll call the meeting to order. This is the May 12th meeting of the Tennessee Real Estate Appraiser Commission. We're holding this meeting at 500 James Robertson Parkway, Davy Crockett Tower, Nashville, Tennessee. First item is to adopt the agenda. Is there a motion to adopt today's agenda?
So moved.
Motion by Commissioner Hall. Second? Second from Commissioner Johnson. All in favor say aye.
Aye. Aye.
Any opposed? None opposed. Motion carries. We'll start then with introducing ourselves and roll call. So beginning with my left, Commissioner Standifer, please state your name and where you're from.
Gary Standifer, Franklin.
In Walton, Collierville, Tennessee.
Norman Hall, Brentwood.
Michael Green, Johnson City.
Mark Johnstone, Jackson.
Rosie Johnson, Paris.
Eric Collinsworth, Arrington.
Excellent. Thank you, Commissioners. Thank you for your attendance. Next item on the agenda is to review and either approve or disapprove or edit the April Commission meeting minutes. Is there a motion?
Move to accept.
Motion by Commissioner Hall to accept. Is there a second?
Second.
Second by Commissioner Collinsworth. Any discussion? Hearing none, all in favor say aye.
Aye.
Any opposed? None opposed. Motion passes. Next item on the agenda is the report of the experience interviews. And at this point, since I did the first interviewee, I will turn the commission meeting over to my assistant, Commissioner Johnstone.
Thank you, Mr. Chairman. At this time, we will entertain the reports from Mr. Green's interviewee. Is there a recommendation?
Yes, sir. I interviewed Richard New. He goes by Rick, and he has not yet taken his exam, but he's upgrading from trainee to certified general. And I found Mr. New's reports to be more than satisfactory, and I would recommend that, subject to the exam, we approve the upgrade from trainee to certified general.
Okay, you've heard the recommendation from the chairman from approval of trainee to certified general for Mr. New. Is there any discussion? If not, all in favor signify by saying aye.
Aye.
Any opposed?
We need a motion.
Yeah, I think we actually need to.
Well, if a committee recommendation, well, depends on the rules of the body. I'm thinking about the Madison County Commission. If we have a committee recommendation, it doesn't require a second. So let me back up. We'll do it that way. Do I have a motion to approve
Moved.
the recommendation? Okay. We have a motion from Mr. Collinsworth. Do we have a second?
Second.
From Ms. Johnson. We have a second. Any discussion? If not, all in favor signify by saying aye.
Aye.
Any opposed? Motion approved. Mr. Chair, you are back in charge.
Well, thank you. All right, next interview was conducted by Mr. Collinsworth, who interviewed Brian George.
Yes, I had an interview with Brian A. George, Andrew George, and he is applying to move from trainee to certified residential. He has not yet taken his exam. Had a good interview with him, and I feel that he's definitely more than qualified to move forward in his process. So I would recommend that we move to accept.
Okay, and you said he has not taken his exam yet? Okay.
Yeah.
All right, so this will be subject to the exam. Is there a motion?
Make the motion that we allow him to move forward.
Second, motion by Commissioner Walton and a second by Commissioner Hall. Any discussion? Hearing none, all in favor say aye.
Aye.
Any opposed? None. Motion passes. Next interview was conducted by Commissioner Hall, who interviewed Richard Andy Crook. Commissioner Hall, what is your finding?
I met with Andy this morning. We had a good discussion, and I feel like he's very well qualified to move up to CG, and I would recommend that he be approved to take
Excellent. You heard the recommendation. Is there a motion?
So moved.
There's a
Second.
motion by Commissioner Standifer, second by Commissioner Walton. Any discussion? Hearing none, all in favor say aye.
Aye.
Any opposed? None opposed, motion passes. All right, next interview was conducted by Commissioner Johnstone, who interviewed Brad
Gaucher.
Gaucher. Commissioner Johnstone.
Mr. Chairman, I had the opportunity to interview Mr. Bradley Gaucher, who's requesting an upgrade from trainee to certified general. At this time, I would recommend approval of that upgrade and to allow him to take the exam.
Excellent. Commission has heard the recommendation. Is there a motion?
So moved.
Motion by Commissioner Standifer, a second.
Second.
Second by Commissioner Collinsworth. Any discussion? Hearing none, all in favor say aye.
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 Any opposed? None opposed, motion passes. That concludes our experience interview report. Next item on the agenda is the education report. Since we do not have an education commissioner at the present time, the report will be given by our capable leader, Mr. Dennis.
Thank you,
Mr.
sir.
Dennis.
We had a total of 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12 courses turned in for approval. We sent them to Dr. Burla, who approved them all as stated in the report. And there was also one individual course approval from Brittany CB Netherland, who had done a 15-hour USPAP update course that she wanted us to use as QE towards her becoming a registered trainee. Dr. Burla looked at that and approved that as well. So we have course numbers 1744, 1745, 1746 from ASFMRA, approved by Dr. Burla. 2 from the Altera group, 1747 and 1748. 3 actually, 1749. 2 more came in later from ASFMRA, 1750 and 1751. The IRWA had 2 courses, 1752 and 1753. The Spearman Center had 1, 1754, and the Georgia Appraisers School had 1 more, 1755, all of which have been recommended for approval as CE.
Excellent. And do you need a vote by the commission regarding these? Okay. Excellent. All right. Commission has heard the recommendation of the Education Committee. Is there a motion?
Make a motion.
Motion to approve by Commissioner Johnson. Is there a second?
Second.
Second by Commissioner Hall. Is there discussion? Hearing none, all in favor say aye.
Aye.
Any opposed? None opposed. The motion passes. The education is approved. All right, excellent. Next item on the agenda is the director's report.
Director's report can be found on your iPads on page 17 of 97.
Excuse me, Ms. Avers, is the iPad copy any different from the hard copy that we
No,
received?
the report should be identical.
Okay, thank you. Please proceed.
Briefly, the bills that had previously passed through legislature have been assigned public chapter numbers, and I just wanted to reference those for your future reference, which is public chapter 621 pertains to the fingerprint background check requirement, and public chapter 570 pertains to the removal of the 30 days prior to renewal. In 113th U.S. Congress, first session, there is a pending act of legislation to change the SAFE Act, which would affect potentially appraisers, and I just wanted to call that one to your attention. At last check, it had passed the Senate, but not the House yet. Discussion for rulemaking planning change is the next item.
Excuse me, Ms. Avers, the SAFE Act's passage and including appraisers within it has impact on what the commission will hear later about the the NMLS system, does it not?
Yes, if they change the SAFE Act to amend the words by inserting "or financial services" before where it says mortgage industry,
Right.
then the appraiser regulatory authorities from each state could potentially opt to use the NMLS, which is the licensing database that the mortgage brokers use, and any creditor. So.
I just wanted to alert commission members, because the NMLS is going to come up later in this meeting. So this federal change is important to us.
And that would just give us the authority to use the mortgage system if we wanted to. For discussion of the rulemaking changes, Commission would take a minute to review the criteria for disqualification, and if there's any changes on that, please let me know. It hasn't changed. It's page 53 in the criteria book, and on your iPads. Actually, I printed out a copy of the rules for everyone, and that would be under page...
These are the proposed rules?
Proposed rules. It would be on it begins on page 17, the denial of a license or certificate. If you have any additional recommendations before we have rulemaking, please speak now or forever hold your peace. Rulemaking.
When do you anticipate the rulemaking hearing?
We're hoping if the commission votes, and I just was going to recommend a whole approval vote. If they vote for approval of the proposed language today, then we'll have the meeting in July, the rulemaking hearing in July.
Okay, and you help us, we're still catching up with you. You said page 17 is where this language is. Is that the document, is that the rulemaking hearing rules filing form?
Yeah, it's on, there should be numbers at the bottom of the page.
Yes.
Page 17 is where it begins, where it says it's 1255.01.09, denial of a license or certificate.
09. Okay, that's, my page 17 is 1255.01.11. 1255. Oh,
Okay.
was it this morning's version?
Yeah.
Haha, okay. So this, commissioners, that's this packet that was laying at your desk when you
Yes,
arrived?
Yeah, that's that one.
I'm sorry.
There
Okay.
were some last-minute edits, and I'll point those out as we come to them. It really was mostly formatting and reference editing. No content changes, just formatting and editing.
Okay, I'm with you. And no color either, right?
No color, now it's underlined instead of red.
Okay. Okay,
So anything that's new would be underlined.
thank you. I'm sorry, got you off track here.
That's okay.
Go ahead. When you're ready.
And the denial language parrots the AQB's proposed changes, so I think we'll be in compliance unless they change something later on down the line.
You mean the AQB changes things at the last minute?
Last minute, sometimes they do, but
Wow.
the latest version, our rules parroted exactly, well, almost exactly. I wanted to give the commission an opportunity to discuss the language included for distance education. That's a follow-up to our last meeting. Last meeting, you indicated you wanted some time to read the language and formalize some opinions. Also, you charged me to develop a survey for licensees to render their opinions before the rulemaking hearing. I have done that. I gave a speech at the International Right-of-Way Association meeting last Monday, and I gave it to the survey to everyone who was present, and many of them submitted surveys. And we also gave it to the applicants today Copies of those surveys are in color on your desk. It looks like this. And it just gives an opinion on distance education for continuing and qualifying education, gives them a chance to weigh in on that. If the
Savers.
commission
Hold on,
approves it.
just, Commissioner Johnstone has a question, and I don't want you to get too far ahead before he gets it asked,
Okay.
please.
Thank you, Mr. Chairman. Ms. Avers, I was looking at the printout that you had given us this morning, and then trying to cross-reference that with the iPad version. And if it's in red, what does that mean on the iPad? It means it's taken out, or that means that was added? Because when I'm at 1255 1-09, I have to jump down. Anyway, it's not, I'm not, and then I get to areas that's underlined. So is it red and black all in the ruling, or is the red out and the black in?
Red is out at 3:30 on Friday afternoon. Our chief counsel made some recommendations for editing and had some questions for references. It was, an hour before we had already compiled the documents for the iPad, so I printed them out this morning, so you would have the final version. It's saved. It'll be the language included for rulemaking if the commission approves.
Can I,
Paper version is the correct one.
the paper version is the correct one?
Just pretend like the everything you see underlined is underlined and in red, and everything that you see,
So if it's underlined, then it's coming out.
No, that's coming in.
it's new.
It's new.
Okay,
Anything
so-
has a line strike through, that's
Out.
that's coming out.
Okay, so if it's underlined, it means it's red and it's being added to.
Yes.
Added to new language.
And if it's stricken, it's stricken.
Yeah.
Okay. And if nothing's done, then it was there and it stayed.
It was already there, yeah.
Okay. Now I'm clear. Thank you. I'm sorry.
You were about to say something about a vote on QE or CE.
Right, if the commission approves to move forward with the rules as indicated today, this final version, then I will send out a survey to all the licensees that have signed up for Notify, and hopefully we'll get a good amount of feedback on whether or not the licensees are in favor of a change. Rulemaking is the actual final, so if you get a whole bunch of negative feedback for any part of the rules, you'll get to hear, we'll read any written comments, and people have an opportunity to attend the rulemaking, to vocalize their opinions on any potential changes. Anything that's not an AQB requirement, the commission could vote to change in the rules. Really, that specifically pertains to whether or not to allow distance education. Everything else that was included, and maybe the language on denial. There's some parts of the language in denial that the commission has some interpretive ability.
Thank you. Well, and let's be clear, Commission. All you're doing today is agreeing to set a rulemaking hearing, at which time we will hear from the public, and then we will discuss and we will vote, and perhaps edit. So we're not making any decision on these rules other than to say we're ready to make a decision on these rules. And
This would be the version that's released out to the public for their opinion. So that's what you're really approving today, is for release for rulemaking notice. Is this okay?
Commissioner Hall has a question.
Just to make sure I'm clear on what we've been asked to do, we're not being asked to approve the language as written. We're only approving for this particular version to be submitted to the public for their observation, correct?
Right, if you don't favor a particular part and it's not an AQB requirement, you could vote to deny at the rulemaking hearing if you chose to.
Have an opportunity to review this after we get the responses back in, before it goes to a vote?
Well, we'll read all of the comment letters at the meeting, and you'll be given ample opportunity during the meeting to formulate an opinion, take your time. That's the bulk of the next meeting is for you to deliberate and determine what course of action to take on the rules.
Consequently, we may change anything in here at a later point before it becomes a rule.
That's the rulemaking hearing is the final time, yes. This is just for release to the public. When you vote at the end of the session on rulemaking, whatever the decision of the commission is, that's how the rules will read.
Commissioner Johnstone made a good point. He's saying this is like an exposure draft. And if you, I mean, this is probably a good time, Commissioner Hall, if you have, we've noted some concerns by various commissioners about various portions. If you have, well, we'll get to that. We'll get to the public debate and the public input, at which time if you have major issues or proposed alternative language, bring that forward at the next meeting, please.
Thank you.
Thank you. Johnstone?
Thank you, Mr. Chairman. This is for Ms. Avers. Once this is released to the appraisers, does it just go to the appraisers, licensed appraisers and trainees only, or does it go to anyone in the public domain?
Anyone in the public, and we're going to specifically add all the schools to make comments.
Will the survey accompany this, or is this a separate item?
I'm going to send out the survey first, and the rulemaking notice will be posted here shortly, as soon as the attorney have an opportunity.
The actual rulemaking won't be emailed to people. It'll be posted, and a notice sent to all of these individuals saying it's posted for you to go online and review.
It might be attached as a PDF,
Okay.
but it will definitely be on the website for public.
I'm not being clear, I'm sorry. Will these both be in one email to people, or will they be in two separate emails?
I'm not sure if the rules will be included on the email. If not, it'll just be a notify announcement saying, click this link, and it'll take you directly to the document.
Will this, and for these to be, some people may not want to put their name on them. Is it going to be tossed out if somebody didn't do that?
They don't have to put their name on it
Okay, it's not
technically, but I don't
mandatory.
know how the commission can give it credence if they want to submit their opinion anonymously. I don't know.
I'm just asking. I mean, there may be individuals.
I guess they could.
Okay.
It's your decision how to weigh it.
If it's going to go to, I guess if it's going to go to everybody in the world, instead of just, I didn't know if it was just going to licensed appraisers, then your response is coming from licensed appraisers. If it's wide open, then you don't know what you're getting back.
I would imagine most of the responses will come from appraisers or trainees.
Schools.
I assume when this goes out, we will make it clear to the reader that this is proposed and not passed.
Yes.
Thank you.
Other questions about the rulemaking process? Now, do you need some votes from us before you move on with the rest of your report? Do you need,
There's a new section in there that I wanted to call to your attention that it wasn't included in the last meeting. It's way to the end of the rule-making document. Sorry. Page 26. The fingerprinting section is new. This is language proposed by the general counsel, and it's just to make sure we have adequate reference in our rules to the fingerprinting requirements. But I'll give you a minute to look that over. Oh,
Commissioner Hall?
At one those instead of having it done again, has that gone anywhere?
yes, that's that SAFE Act that we were discussing earlier. If that SAFE Act is amended to allow financial-related industries, appraisal included, then we could subscribe to the NMLS as a state agency. Applicants could fill out an application requirement, submit their fingerprints once, and then use that to gain their fingerprints. They could use it in every state that they applied to. They'd still have to pay a rerun fee, where if you applied here in 2015, and then in 2016 you applied in Texas or another state, they just have to pay for the report to be run. They wouldn't have to go get their fingerprints done again. They just have to pay to have the report run again on them, just in case they had something happen in between. But the information would be available to all the regulatory authorities. So if you get notified in Kentucky of a criminal action against an appraiser or any credential that's under the NMLS, including mortgage brokers and payday loan companies and a variety of credit-related industries, then that information is available would be available to the state appraiser regulatory authorities also. So we'd know that there was some conviction history. We'd still have to research it, but.
Oh, and as to Commissioner Hall's question, currently, if I understand it correctly, there are firewalls that the feds have built that don't allow the sharing of data.
Yes, that's what I was asking about.
The SAFE Act change would allow the sharing, so that's what's.
To some degree, yes. To some degree of sharing, yes.
Any other question, Commissioner Hall?
No.
Okay. All right, any other changes to these rules besides the fingerprinting section?
I can't recall off the top of my head if you had an opportunity to read the military applicant rule, which is on page 36. I think it was proposed before the last meeting, but I'm just not 100% sure. This is a specific requirement in Tennessee law that all boards recognize expedited licensure for certain military personnel and their spouses. It's not a substantive change. I really don't believe that this rule will ever be.
I think we reviewed this last month.
We did.
I just wanted to make sure I didn't skip it and then you all are surprised later. That's
Okay.
it. If you want to vote separately or as a whole, and then Keeling has some regulatory flexibility analysis things that she needs to read, and you can vote on that as well.
Okay, well, so what, as far as, you need a vote from us as to bring these rules to the full rulemaking process, correct?
Yeah, just approval to move forward or not.
And then, do you need something regarding QE and CE or not? Or is that incorporated herein?
Those rules are included in there for the distance education. The commission could vote to throw it out now or proceed to rulemaking hearing, get the feedback from the licensees, and then approve or deny it at the rulemaking hearing. That's your call.
Okay. All right, well, is there a motion then regarding these rules and the rulemaking hearing process?
So moved.
Okay,
Go
what is your
forward.
motion?
Make the motion that we go ahead and proceed forward with the exposing this to the public
In conducting a rulemaking hearing?
and conducting a rulemaking hearing
Okay.
for at some future meeting.
I'll
Right.
second that.
Excellent. So a motion by Commissioner Walton, a second by Commissioner Collinsworth. Is there further discussion? Hearing There is further discussion. Commissioner
One
Stanford?
question earlier, you had talked about the responses. Are you going to when will we get the responses? Will we get those prior to the meeting or at the meeting, or how will that work with regard to the input?
Definitely at the meeting. I might be able to get information to you sooner, but then that also leaves out the possibility that somebody submits information last minute, that you wouldn't get it. Everyone who submits comment to the commission on the rules, those comments have to be considered. So
Oh,
we
and-
will
But
get
what,
it.
I guess one other question, do they have to be signed to be considered or not?
Technically, no. Requirement that they have to sign it. They could submit it anonymously, but you all have to weigh how much consideration that would be given.
Get everything, whether it's signed or not, so,
Yeah.
okay.
Well, and you will have the opportunity during the meeting, we'll have guests, and you'll ascribe whatever personal weight you want to. Commissioner Johnstone?
Thank you, Mr. Chairman. As I read through the survey, it looks like it's going to be pretty easy. It's either, you either support it or you don't support it. I mean, there's not a lot of room in there for you to write a narrative response. So I would think that Ms. Avers could provide that back. Question 1, 82% of the respondents said X, 10% X, and the balance, no comment, something to that effect. So you wouldn't actually, to be honest, I don't want you to email me 400 of these. I just want to know what the numbers are.
And there is at the end of that survey an opportunity for them to write comments if they want to elaborate more on their answers. Those will get considered. I will have them all
Yeah.
here. I'm not going to cut anyone's comments.
Yeah. You could just attach those to the bottom, and I mean, it would be easy for one of the commissioners to look at your email and say, okay, here's the responses, and then here are some handwritten comments that would go along with that. And I think it's really good. Thanks.
I agree. Commissioner Johnstone had mentioned that he would like to see the results in a three-dimensional matrix presented in a holographic image that we could
In color.
manipulate.
I would add to that matrix that I would also,
Like it narrated by Harrison Ford or
if
I was thinking James Earl Jones, but
James Earl Jones.
you're close,
Okay.
yeah.
if there is a way to note whether or not it was unsigned or anonymous, if there was like a percentage, you had like, okay, 2% of the respondents did not sign, then you would know it really didn't have an impact. But if you had, maybe an appraisal school that wants it to go a particular way, they may flood the thing, and all of a sudden you've got 92% of the anonymous responses going one particular way, then it might skew the results. So that would be a way to help provide some kind of sensitivity check. Thank you.
Thank you, yeah. Is there further discussion? Okay, hearing none, all in favor for the motion, say aye.
Aye.
Any opposed? Hearing none, the motion passes, and we move forward to rulemaking.
Who was the second on that vote? I'm sorry, I didn't write it down.
I was.
Okay, thank you. I apologize.
Okay, so we have we're still in the director's report. Do you have more for us?
She needs to do a regulatory flexibility analysis. If you approve that language, we'll move forward with that.
Really fast.
Super fast.
Got it. It's got it down pat here.
Okay, all right.
So what I'm going to do, there are 7 questions that have to be included with the rules, and it's called a regulatory flexibility analysis. It's basically a method of reducing impact of the rules on small businesses. So there's 7 questions that I've sort of gotten answers to. I just need you guys to tell me whether you agree to move forward with these or not.
Help us here.
Okay.
So you would like a motion, at the end of these questions and answers, you would like a motion to approve or disapprove in whole or in part?
Would work better if it was in whole, but like I said, they're not complicated at all.
Okay, well, let's
But we
just get
have
into
to have
it.
2 separate votes, one to move forward with rulemaking and then a vote on the reg flex analysis.
Okay, all right. Well, let's just walk down that road together.
Okay, let's do. The first question is, do the rules overlap, duplicate, or conflict with other federal, state, and local governmental rules? And the drafted answer is, the appraisal subcommittee monitors the requirements established by the states for the certification and licensing of appraisers. The proposed rules articulate the standards developed by the Appraisal Qualifications Board, so there is no overlap. The rules should act in concert with the federal regulation to clarify requirements for Tennessee appraisers. So, I mean, it's a pretty vague answer. These are not super specific. I know it's kind of confusing, but it's always vague. So, if you had something you wanted to add, we can do that. Or not, we can just keep going. They're
Would we
pretty
want to consider just, instead of that, could we just say kinda?
If you want to, we can. We can say kind of.
Couldn't resist.
Those might come back with some red marks, but it's not something I haven't seen before, so.
Please go to number 2.
Okay, number 2, clarity, conciseness, and lack of ambiguity in the rules. The drafted answer is, the rules are clear in purpose and intended execution. The rules are not open to different interpretations. Okay, number 3, flexible compliance and/or reporting requirements for small businesses. The drafted answer is, these rules do not impose any additional reporting requirements on small businesses. I'm just going to keep moving unless you guys stop me. Okay, number 4, friendly schedules or deadlines for compliance and/or reporting requirements. The drafted answer is, deadlines for compliance and/or reporting is January 1st, 2015. Number 5, consolidation or simplification of compliance or reporting requirements. The drafted answer is, compliance and reporting requirements are simple and are no more complex than those currently existing. Number 6, performance standards for small businesses. Drafted answer, the performance standard for small businesses is the same as those operating larger businesses, since the law and rules apply equally to all individual real estate appraisers. And the last one, number 7, is barriers or other effects that stifle entrepreneurial activity, curb innovation, or increase costs. Drafted answer is, there are no known barriers stifling entrepreneurial activity, curbing innovation, or increasing costs.
Thank you. And who are these answers being submitted to?
These will just be submitted along with the rules. They're going to start from the beginning and go through every person.
Go to the Attorney General's office and the Secretary of State.
Okay, so this is a requirement by the state
Yes,
anytime government passes new rules.
yes.
Commissioner Johnstone has a question.
Attorney Bayard, the increased cost question in these questions per se, are they, I mean, a lot of these things, for instance, there are increased costs. The fingerprinting is an increased cost. That's easy to prove that. But that's dictated to us from the federal government. We didn't choose to do that. So are these questions asking, are the things that you as a state commission added or changed, that's in addition to what the feds
Right.
required?
Right.
Are those things causing increased cost? Or is it increased cost in general, which would include what the feds mandated?
I think it means, is it going above and beyond
What's the feds
mandated
mandated?
by the federal regulations?
Okay, thank you.
Because in the first question, when it talks about overlapping or duplication or conflict, to me, that means it's what, if it goes above and beyond what the federal regulations are.
Are there other questions or comments? The only question I have is, and to Mr. Johnstone's point, it might be nice to make that a stronger linkage. That we're doing this primarily because of the federal regulations and to stay in compliance. I personally, I think I could answer false to every one of those. But it doesn't change the fact we have to make these rules. We have to keep Tennessee in compliance. So if the linkage is stronger, I'll feel better about saying yes to all those questions. When do we have to vote on that?
Well, you can just vote that Keeling amend that language, and then it'll be at the rulemaking hearing that'll be read and
Right, I'll just,
voted on.
What I'll do, if you want to vote to amend the language to make the stronger linkage, it would be best if we could just vote on the reg flex today, and then I'll include the new language when we get to the actual rulemaking hearing. And then if you're comfortable with it, then cool. If not, we'll change it to make you comfortable.
Any comments from commissioners on that program? We're not voting, but if you have comments, this would be a good time. We're about to vote.
Might want to just
Go ahead, Commissioner Johnstone.
Well, I would move that we adopt the language as Keeling outlined, subject to amending it with the stronger linkage as explained by Chairman Green.
Okay, so there's a motion on the floor, or on the table. Is there a second?
I'll second that.
Second from Commissioner Collinsworth. Is there further comment? Hearing none, all in favor say aye.
Aye.
Any opposed? None opposed, motion passes. All right. Any other director's report?
Item 2 on the director's report is the information on the CFPB. It is a dilly of a rule draft that the CFPB has issued. I have tried to outline in bullet points what's included in the 96-page document down to less than a page. So, please understand it doesn't include everything that's in there, but it kind of summarizes it, including that the AMCs be registered and subject to supervision, that the AMC only use state licensed or certified appraisers for federally regulated transactions or related transactions, that they require compliance with USPAP, ensure competent and independent appraisers are used, and comply with the Truth in Lending Act. That's all under item I on your thing. The second part is what the states are going to have to be required to do. Approve or deny the applications, examine the AMC and require that the AMC submit relevant information to the state, verify that appraisers on AMC, appraiser network, or panel hold valid state certifications or licenses, conduct investigations, discipline AMCs that violate appraisal-related laws, and report AMC's violation to the Federal Registry. That's the bullet points of it. I included a snapshot of one of the newsletter articles on it. It just kind of clarifies in more detail. One of the problems found with the rules in paragraph 2, the problem that state appraiser regulators would require to collect $25 per year per appraiser on the AMC panel, and that many people have commented is overly burdensome on, because most likely that fee would be passed through to the appraisers. So again, I encourage you all to comment on those rules, because otherwise the CFPB will just move forward on that specific requirement.
Commissioner Johnstone?
I didn't see that on the proposed survey. That's kind of an important one. Would it be possible to add that on there?
The AMC rules are not included in this proposed rulemaking hearing. We're going to have to do that at a later date.
Oh, they're not tied to that then?
Not yet, because the CFPB has just issued proposed federal rules, and then, so we're going to be chasing the rabbit if they change it.
Okay, so I guess my question is, why are we commenting at this time on this one?
I want to get you involved in this as early as possible, because if they pass this, then we're going to have to make that the minimum
comments are
requirement
not
for
coming.
AMCs.
They're not coming for us. They're going back to the feds. These comments are going back to the feds.
Yes, and there's the link down at the website of how to comment on those rules, and you can also find a copy of the draft rules there if you want your own digital copy at www.consumerfinance.gov. Implementation is required 36 months after those rules are finalized, those federal rules. So we have to be in compliance 36 months after their rules are finalized, and the appraisal subcommittee will then audit us for those requirements. currently they're not auditing us for our AMC compliance.
So overriding instruction is for us to comment as appraisers and as the general public and encourage the Tennessee appraisers to comment to the CFPB.
Sure, and, and tell them that you're a board member and what your thoughts are on it. I'm sure Eric would probably feel the same way that I'm telling you. It's like, this is your opportunity to change the federal law. Once the federal law is implemented, there's not going to be anything we can do about it. So, opportunity.
Ultimately, appraisers are going to pay this fee, and if you're on, as residential, you essentially have to be on these AMC panels to get work. If you're on 10 different panels, that's $250 annually.
They're
In
proposing,
addition.
they're proposing to push the monitor and regulating the customary and reasonable fee off to the state regulatory agencies too. So I cringed when I saw that one also. I'm like, oh, great, I get to monitor fees. That's not going to create a difficult position for me as the director of the appraiser commission,
That just
I can
chatter
very
is,
easily it can very easily be interpreted as fee setting by the board.
that,
but
to
that's-
me, that's, as board members, that's more significant to the board than anything.
Mr. Chairman,
Commissioner Hall?
that would create a problem, because then we'd be accused of price fixing if we start doing that. And,
I sent you all links to those rules. I know it's 96 pages, but I'm telling you, once the federal law gets implemented,
Someone
some
need
of the
to,
language in there is very good, but some of it makes my hair curl. It's like,
do they ever read this stuff before they ever put it out? I mean, it doesn't appear they do. I mean, it's getting really appalling what we are reading coming down out of Washington.
5 banking agencies got together and proposed these rules. So, all of FDIC, OC. They got together and drafted these, and then once they pass it, they're going to expect compliance from both the banks and the appraisal regulatory officials. I didn't draft these rules, so this is me telling you, comment. I'm trying to give you the bullet points of what's in there.
thank you. Well, we've got all these acronyms and all these agencies. There's an acronym agency that comes to mind called the FTC that might be keenly interested in us setting customary and reasonable fees.
It's a little horrifying. I mean, I've heard some easy recommendations, like whatever the VA say, and please understand that this applies to residential. This is very much tied to residential, but using the VA fees, whatever the VA panel puts together, that's what everyone gets paid. I don't know how that really relates to Fannie Mae, Freddie Mac lending, but again, comment. Change isn't going to come from just me giving them my 2 cents on it.
Help reinforce what you're saying. The problem with tying it to VA is the fact that VA will adjust their appraisals based on what is the other appraisers are getting in the area for their reports. So, for instance, if VA is paying $400 and everybody else supposedly are willing to work for $200, then you're not going to plan on if they're getting $600, then you might get an increase. But the problem being, that's in effect is VA will become now the one area that will be setting fees for the entire country. And I know VA hadn't had an increase in their fees for the last 5 to 6 years, but yet they keep increasing the federal rules as to what they want in their appraisals. So this is, I don't know the answer, and I appreciate the work that everybody here is doing on this, but it's a real concern.
Take some time and read it, because the comment period is coming to a close.
Well, and it would probably warrant, I think this is extreme enough, this would warrant a bulletin to the appraisers on your notification list. I forget what you call it.
E-notify, yeah.
I think we should e-notify the appraisers in the state that there are some major changes that warrant their attention and their comment, and it would be also, it would warrant a block of space on our homepage on our website. We are somewhat the conduit for federal activity, so let's exercise that function.
I would like to make a quick comment. As a residential appraiser, regarding customary and reasonable fees, since the implementation and really takeover of the avenue where we gain business by the AMCs, you've seen a continuous appraisal fees, to the point where most of the time the appraisal fee that I'm offered by an AMC being contacted is less than I was getting 10, 15 years ago for residential appraisals. And
Well, that might
yeah,
not be
I don't understand
pertinent.
how that could be customary and reasonable.
Let's be
given-
careful. Let's be careful commenting on these matters. If you have those types of conversations and those kinds of thoughts, please relate those as from a businessman's perspective more than as a commissioner's.
Correct. I understand. I'm trying to give voice to other appraisers, though, out there that may be experiencing the same things. And I know it's from a regulatory perspective, it is. It's a two-edged sword. We can't be going out dictating fees at the same time, too. I think there needs to be some thought given to it.
Thank you. Any other commissioners? Okay.
Texas did a survey on customary and reasonable fee. I tried to develop a survey on customary and reasonable fees, but, and opt to do that, but it really gives me pause that the authority, could you imagine the complaints and processing them and hearing them, and it just really gives me pause as a regulator to go, you want us to do what? It's a scary concept, because then.
For all of us.
Right.
There are depths to this we can't even comprehend yet, so.
So read it, see if you interpret something different from those rules. If you need me to send the link again, just email me and I'll shoot it out to you, but it's very important that everyone knows that this change is, it's whatever it's going to be, it's going to be a federal requirement, just like our appraiser AQB requirements are. So it's going to be a requirement that we comply, and will be audited for compliance, and that could really affect every appraiser on the registry as well as the AMCs. So if we don't comply, then they don't comply. It has a very run-down effect, trickle-down effect. If we get audited by the subcommittee and they say, well, you're not enforcing your AMC requirements because of whatever, so we're kicking Tennessee out of the good compliance status, it could affect appraisers. It's going to affect everybody.
If that were to happen, then, and we were kicked out, for example, from compliance for that, then you would not be able to have an appraiser, an AMC company, do anything at all for federally related transactions. That would have a rather major impact on the
And
appraisal
that's-
industry.
And it also
We don't
has
want to
an-
be alarmist.
Yeah,
That's
I don't
an
want to be alarmist,
extreme
but
case.
that also
yeah.
is a reason for reciprocity to shut down, because if we're not in compliance, then no state has to grant our licensees reciprocity. So it has big effects, like that status we get from the subcommittee. I know you guys don't see them very often. They only come around once every 2 years, but our compliance status is actually a very important part of what we do.
It's why we do a lot of things we do. Commissioner Stanifer.
We're gonna have a section on our homepage or our site to make people aware. Would the link be available there?
Absolutely, I'll make it happen. I'll make it happen, and I'll try to get it on the e-notify. I might not be able to do that, but I will try. I don't think that the administration will have a problem with me notifying the appraisers on something that affects them. And the AMCs, we'll add them too. It's not hard to add the AMCs.
Would a motion from the commission better arm you for that argument?
You don't have to vote, but you can if you want to. I will do it regardless if you.
I would entertain a motion to solidify our position.
I think she'll carry through with it, but if you'd like a motion, we can certainly do that. I would make a motion that we provide a place on the website, and the link would be appraisers within this state to weigh in on this subject.
Second that.
We have a motion from Commissioner Stanifer, second from Commissioner Collinsworth. Is there further discussion? Hearing none, all in favor say aye.
Aye.
Any opposed? None opposed, motion passes.
Item 3 on the director's report is just some information on the AERO conference. It was very informational. I think Mr. Green would agree a lot, and it was there was some big information. The first one I have itemized is there was a great session by Rachel Dollar of the Mortgage Fraud blog. If you haven't signed up for her blog, it is like the best read ever. So,
Excuse me, I'm going to pass this. This was the conference schedule, who was there and when it was presented. I'm going to pass this amongst commissioners while you speak. Thank you.
problem at all, and I helped design that, so some of my handiwork there. The big thing that happened at the AERO conference is the AQB voted to extend the fingerprint background check requirement for enforcement to 2017. That means that, states can have it in effect currently, but the ASC can't monitor us for that requirement until 2017 while they work out whatever disagreement on language. I don't believe that anything that I heard indicated to me that our language, if as approved, would be out of compliance. So if anything, we're just getting it in that section of the AQB requirements a little ahead of schedule now. So I strongly recommend we just move forward on this. There was a lot of effort put forth to get the law passed, and
Well, and that's important for commissioners to note. Tennessee law has been implemented. It's been signed. So Tennessee's law reflects the fact that we have fingerprinting. So now we're just, even though the AQB has, and I was alluding to that earlier, even though the AQB has slid our deadline back, we still have a Tennessee law that we need to make rules to comply with. So, go ahead.
So that was interesting. The Standards Board updated AERO on the changes that they're working on for 2016-17. I included that information on your iPads. Significantly, they're going to be working on that draft report issue that they've been working on for the last 5 years, I think. We had a session on developing and maintaining supervisor trainee course. It seems as though most of the largest schools are developing 4-hour courses to meet the APB requirement. I gotta set this book back. If Tennessee is going to require a 7-hour course, as indicated from the last meeting, we might want to consider approving the course in 2 parts, an AQB part, 4 hours, and a Tennessee-specific part in 3 hours, just so that some of the larger schools that are not going to do a 7-hour, we can still maybe utilize that information and just have a venue for some of the smaller schools to just hold the 3-hour session and get everyone in compliance. We already discussed the NMLS part. I just wanted to include it in the report. There was a lot of discussion on the NMLS, possibly be allowing us authority through the SAFE Act. It'll be cost effective for our licensees, especially those that have credentials in multiple states. And it'll tie in on that wrap back system. I think I talked about this at previous commission meetings where a violation or a conviction after you're licensed. As the states improve their reporting requirements to the FBI, more and more of the counties will be able to give that information to the FBI, and the FBI will be able to essentially wrap back to the state regulatory agencies where the person holds a license and say, hey, John Doe has just been arrested for whatever.
Are you pronouncing, is it RAP? R-A-P?
Wrap back,
Not-
R-A-P.
Not R-A-T.
No, not
Okay.
rat.
I just want to make sure.
And then there was a discussion on the CFPB and the banking updates. I'm actually sorry Mr. Collinsworth missed it because it was there was a lot of discussion on the multiple banking changes taking. To get a copy of the PowerPoint from the session, you might want to delve
Love
into
to see
that,
that.
because Crispin Bennett is just like a genius. And he's a compliance officer for a bank, and he just knows all of those things, and you might use his information to your advantage. On the last page of the report is just an update where we are with the budget and the total number of licensees. And with that, I conclude my director's report.
Thank you, Ms. Avers. All right. Next item is Chair's report on the AERO meeting as well. And Ms. Avers has really hit the high spots well. I don't have a whole lot else. These are more layman's views, I guess. Yeah, some facts I thought you gentlemen and ladies might find interesting. In California, who has had background checks for some time, 15 to 30% of applicants have a rap sheet already. And over 50% of those the rap sheet involves DUIs. I thought that was interesting. California, when they evaluate the rap sheet, they look at whether the convictions were substantially related to fitness to practice, and they look at whether the convictions, whether they have been rehabilitated in terms of honesty, candor, integrity, and truth. So they look at, are they still lying about it, and are they showing integrity in what they're trying to apply for. The AQB, a couple of interesting points I noted. AQB regs demand that you can't supply a license if they've had a felony within 5 years or they've committed a violation regarding fraud, dishonesty, or deceit. So I thought that was interesting. California, and I only reference California because that's who was there talking. So they won't issue a license if the conviction involved forgery, debt evasion, drug trafficking. And it was interesting on DUIs, they said if you had one, probably you'd get your license. If you had two, maybe. And if you had 3 or more DUIs, forget it. They're not going to give you a license, which I thought was interesting. Let's see. I'll try to be brief here. NMLS, I thought it was interesting that Tennessee's bankers are not currently members of the NMLS. They listed a roster of states that participate, and Tennessee's do not.
That was a typo.
Oh, it was?
It
Because
is.
Wilma,
Yeah, they are. Yeah.
They are, and the
Okay, well, thank you.
yes.
Yeah.
Okay.
the previous chair or president or whatever they call it was Greg Gonzalez, who is the head of the Tennessee Department of Financial Institutions. He was the actual chair of the NMLS.
Good, I'm glad to hear that, but it does show us paying attention, so, all right. Let's see. Regarding the supervisory trainee class that's going to be required, Nicole mentioned 4 hours versus a 3-hour add-on. I'm personally in favor of that. We'll see how the commission votes. I thought one speaker presented it really well. We need to look at what it is to be a supervisor versus a mentor versus a teacher. And how do we want this class to talk about all three? Or do we want it to be strictly, leave the mentoring and teaching to the private sector? I don't know. We'll find out what the commission's feelings are. Some other things, if we do the 3-hour increment, some other things that might get covered, business aspects like tax structures and letting trainees know about the fact that they're independent contractors or versus employees, common deficiencies. What are the reasons to terminate your relationship with your supervisor? And conversely, what's the relationship? When should a supervisor terminate their relationship with a trainee? Some states consider supervisory appraisers as a credential. So not only are you either a certified general or certified residential, but you are a supervisor. You have the supervisor credential, and which I think is something to look at, since it would give, we have people that are struggling to get into the business. It would allow them to go to the website and say, all right, here's all the people that have the credential, rather than not knowing which CGs are supervisors. This question has come up amongst the commission in the past. In South Dakota, for instance, if you've not had a trainee in 3 years' time, you must retake the supervisory trainee class. So it kind of keeps everybody current. So grandfathering is relative in most states, I think. Last thing I'll mention, we had a great session on mortgage fraud from the FBI and this attorney in California named Rachel Dollar, who appears on a lot of different blogs and stuff, and it was fascinating. And ironically, a lot of the content that was presented in the mortgage fraud blog, we've seen those things cross our desk here on this commission. So,
Talked through a case study on a case that was in the area of Tennessee, where it affected North Carolina, South Carolina, and Tennessee. This licensee just went like all over crazy over there.
like a virus.
From beginning to end, she talked about all the parties and how they're involved and how they got caught, and she talked about a case study for mortgage fraud, like beginning to end. It was really interesting.
It was very beneficial, and I think we'll continue to see the impact that AERO was making on both our director and our state body. So I highly recommend that future commissioners go to AERO. I really do. And that's all I had. If you all have any questions, I'll be glad to answer them regarding AERO. Okay. All right. Well, that's
Might not be too early to consider who you want to send to fall. In the fall, it'll be in October. I can't remember the exact day. I think it's on that brochure. I think it's the 18th through the 21st. The board can send 2 representatives plus staff to the AERO conference. So you might want to pick which 2 people.
And based upon my attendance, I would encourage someone to make a motion to send the incoming chair, and the AMC rep, the AMC commissioner on the board. That, from experience, that's what I would recommend. Is there a motion to that effect?
So moved.
Second.
Motion and a second. Is there further discussion? All right, hearing none. All in favor say aye.
Aye.
Any opposed? None opposed. Good, okay. Next item on the agenda is the 2015 rules, but I'm wondering if the commission might like a quick break for restroom access. Before we do, though, Ms. Avers, do we have more to discuss regarding 2015 rules?
Oh,
We covered that, didn't we?
The next item is the legal report, and then we got a quick legal presentation, and then we're done.
Okay, well, let's take a short 10-minute recess. We'll be right back. Okay, the Tennessee Real Estate Appraiser Commission is back in session. This is Monday, May 12th. And we have reached the point in our agenda where we are ready for the legal report. And I understand that there is also a presentation regarding legal matters. Is that correct?
Yes. If
And-
Damon can get access to the laptop, there will be the presentation.
Okay, well, in the interest of efficiency, let's go ahead and process, since all commissioners are present and accounted for, let's process the legal report, please. And please introduce yourself with your new married name, barrister.
Okay, I am Keeling Gamber,
Thank you.
Assistant General Counsel for the Real Estate Appraiser Commission. And if you guys are ready, we will start the legal report.
We are. Please
How do
proceed.
you spell that last name again?
Like gambler without the L. Gamber.
Or like camper, but with a G.
Correct.
Or, no, thank you.
And we are happy campers, so that fits. Okay. Item number 1, 2014005381. Complaint was filed by a real estate agent who represents the seller and alleged respondent does not have the proper tools to enter the property, which is a Centra card. Complainant alleged that at the request of his sellers, they will not allow anyone to enter their property without going through the Centra lock system, which requires the Centra card. Complainant alleged respondent informed them that the commission does not require them to have a Centra card, therefore they will not get one. Complainant alleged this is a huge inconvenience. Communication was sent to the complainant from this office explaining that the Centra card access is not under the commission's authority and inquiring as to whether complainant wanted to withdraw the complaint. The letter was returned marked unclaimed. The subject of this complaint is not within the jurisdiction of the commission. As such, council recommends this matter be closed with no further action.
I move we close this with no further action.
Second.
There's a motion by Commissioner Collinsworth and a second by Commissioner Walton, because no one else could make one any quicker than those. Is there any discussion? Hearing none, all in favor say aye.
Aye.
Any opposed? None opposed, motion carries.
Item number 2, 2013009201. This complaint was filed anonymously and alleged respondent's report included the highest and best use of the land as a proposed assisted living facility, and the land could not be legally used for that purpose. There was no mention of the current zoning or mention that the land must be rezoned. The income approach data was prepared by Cecil McNatt's, not market rates. Complainant alleged the financial loss to the company exceeded $200,000. Respondent responded to the complaint, stating that complainant indicated that the appraisal was completed in 2010, when actually it was completed in 2008. In addition, respondent stated that the vacant land comparable sales in his appraisal were located in close proximity to the subject and are similar. Respondent also stated that the site value that was indicated by complainant in the complaint was an incorrect statement, and the site value estimate in his appraisal was a much lower number. I've listed the reviewer's conclusions there for you to review. There's quite a few of them, so I don't know if you need time to look over those before we get to the recommendation, so you can just let me know.
Does the commission need time to review them? Okay, we do need some time, so just let me know when you're done reviewing those, please.
Chairman Green, also I wanted to let you know I need to abstain from this.
Okay, thank you. Commissioner Walton is abstaining. Familiar? Commissioner Hall a minute here. Everyone's familiar with the reviewer's conclusions. Ms. Gamper, would you like to conclude then on this item number?
The recommendation is the authorization of a $500 civil penalty to be satisfied within 30 days of execution of the consent order, to be settled by consent order or form.
Okay, so we've heard legal's recommendation. We can hear a motion or we can hear discussion. Commissioner Johnstone, would you like to start?
That just seems kind of weak recommendation based on that. That's a pretty extensive list of issues on a complex type property.
Okay, thank you. Other comments from commissioners?
I agree with Mr. Johnstone, and I wanted to make one quick point also in regards to the reviewer's information. I'm wondering if this is a typographical error. The last bullet says under USPAP guidelines, this is a summary report, however, due to almost complete lack of description, it's more likely this would be considered a limited use report. Are you guys familiar with that type of a report?
They did away with all of that kind of language years ago. There was a limit.
Yeah, that's what, I mean, I guess I was being sort of silly in my question. Limited was removed in 2006.
Yeah.
And I think we need to make sure our reviewers are aware that even back in whenever this was,
Restricted use.
yeah, I'm
probably.
hoping that was what he was meaning, but, okay.
Well, that's a good question.
I was wondering if it was a typographical error and it should have been put as a restricted use report, possibly on the reviewer's findings, but, because this was supposedly written in either 2008 or 2010, and limited was long gone before that in either case.
Commissioner Hall?
Did the accused have an opportunity to respond after he got a list of the reviewer's comments?
Yes.
Did he?
I did not receive any response prior to this meeting.
I have comments. I'll go ahead next. I've counted up the bullet points, and the majority of my bullet point analysis is that these involve appraisal procedures, whether it's the sales comparison or the cost or the income approach. And then second most flagrant are USPAP violations. So my thought is consistent with the other commissioners. I think the legal's recommendation is very light, and my thought is that a couple of additional classes and a heavier fine is in order. And I would say procedures and USPAP and a heavier fine. That's my personal opinion. Any other commissioners want to weigh in? All right, hearing no further commentary, is there a motion?
I would move that we do increase legal's recommendation to at least the principals class, and then I would suggest the 15-hour USPAP if we can do that as well.
Principles and procedures.
I'm sorry, the procedures, and then the 15-hour USPAP. Yes, 30-hour procedures class, 15-hour USPAP. From a penalty standpoint, I would suggest maybe a $1,000 penalty if that's possible, based on this.
Okay, so, well, and anything is possible. Just to answer your question, you can, the commission, it's at your latitude to decide what's appropriate. So, and the respondent will have the chance to contest this. So this is just what we're finding. So The motion was to require a 30-hour procedures class, a 15-hour USPAP class, and a civil penalty of $1,000. Is there a second?
I'll second.
Second from Commissioner Johnson. Is there further discussion? Hearing none. All in favor of the motion say aye.
Aye.
Is there any opposed? Hearing none, motion passes. All right, item number 3.
Item number 3, 2014-002541. This complaint was opened by the administrative staff for the Tennessee Real Estate Appraiser Commission because the respondent applied to reactivate his certified residential license that has had multiple convictions. The respondent was previously disciplined for prior convictions relating to theft and drug possession and received a final order which required a $1,000 civil penalty plus costs and 1-year probation. The probation period ran from August 10th, 2010 to August 10th, 2011. There were multiple additional arrests which resulted in 2 prior complaint matters which were closed because the respondent, in consultation with his attorney at that time, elected to place his license into inactive status while he resolved the arrests and sought substance abuse treatment. There is a list there, some convictions that were found through county records in one Tennessee county for the respondent, and this is since the above mentioned final order. So all these things have happened since then. There were additional arrests not listed above that did not result in convictions. Respondent submitted an application to change his status back to active, which was approved by this office and became effective March 5th, 2014. There were 2 prior complaints that had been submitted to our office, which were reopened with application to become active as a real estate appraiser. Respondent was sent written communication from this office asking him to show cause as to why his certificate should not be revoked for his guilty pleas to dishonest and fraudulent actions or omissions, and for conviction of multiple misdemeanor offenses and crimes that substantially related to the functions and duties of appraiser in violation of TCA 6239-326, 3, 4, and 5, and 6239-329. Respondent's attorney sent a response to the complaint stating each of the arrests that this office asked respondent to respond to have been dismissed. Such arrests consisted of the following, and I've made a little list there of the different dates that those happened. Respondent's attorney stated that there are no criminal charges pending against respondent at the current time. While respondent's attorney does admit that he did plead guilty and was convicted of such offenses of assault, DUI, reckless driving, probation violation, leaving the scene of an accident, public intoxication, escape, simple possession, Schedule 4, etc., in General Sessions Court, he contends respondent has never been convicted of a felony. Respondent's attorney submitted the misdemeanor offenses listed do not involve dishonesty, fraud, or misrepresentation, or are not offenses substantially related to the qualifications, functions, and duties of a person developing appraisals and communicating appraisals to others. Respondent's attorney stated that in August 2013, respondent's real estate broker's affiliate license was revoked by the Real Estate Commission for failing to report a conviction. This was an oversight on respondent's part because he has not been actively involved in affiliate broker sales since 2007. His attorney also stated that respondent's convictions are all related to his problems with substance abuse and addiction. He has successfully completed a lengthy inpatient rehabilitation program in 2013 and has passed all his drug screenings since that date. Respondent is now drug and alcohol free. Respondent's attorney stated that respondent has had his appraiser's license since 2002 and has performed hundreds of appraisals and has never had any problems with any of those appraisals. The attorney also submits that respondent's rehabilitation should be considered in mitigation of any penalty the Real Estate Appraiser Commission is considering in this matter. The respondent's attorney suggested that a lengthy period of probation with civil penalties would serve the interest of the commission and allow respondent to continue to work as an appraiser. So we've listed the license history that has already been explained there, as well as the complaint history. On the reasoning and recommendation of listed TCA 6239-326 states, the rights of any applicant or holder under a certificate as a state license or real estate appraiser may be revoked, suspended, or restricted, or the owner of the certificate may be assessed a civil penalty of up to $1,000 per violation, or otherwise disciplined in accordance with this chapter on any of the following grounds. conviction, including conviction based upon a plea of guilty or nolo contender, of a crime that is substantially related to the qualifications, functions, and duties of a person developing appraisals and communicating appraisals to others, or conviction of any felony, an action or omission involving dishonesty, fraud, or misrepresentation, or a violation of any of the standards for appraisals and appraisal practice as set forth in this chapter and the rules and regulations promulgated by the Commission. As such, council recommends that respondent's credential as a certified residential appraiser be revoked, effective immediately upon execution of the consent order ordering revocation. Such terms are to be settled by
All right, well, you've heard the recommendation of legal. Is there a motion or discussion? Either one.
Motion to accept the recommendation of council.
Second.
Motion by Commissioner Hall, a second by Commissioner Johnstone. Is there further discussion? Hearing none, all in favor say aye.
Aye.
Any opposed? None opposed, motion passes.
item
Oh,
number.
before you move on,
Sorry.
I'm sorry.
No, you're okay.
Back to item number 2, case number 2, and I'm not going to reopen this, other than, would the commission like to send some type of a message back to the reviewer regarding staying current on USPAP? The limited use report versus
I think that would be a good idea.
Director Avers, what form should that take? Do we need to? I want to send the message really strongly that our reviewers reflect the professionalism and the competency of appraisers in the state. And if they don't set the standard, no one else will. So whatever means is necessary to send that message is what I'd like to use. And I'm not sure a memo is strong enough. I think a letter to all reviewers stating we expect excellence is in order. That's your chairman talking. That's, if someone wants to make a motion, or if you need it more formal or more strong, I think we can arrange that. But else have feelings on the matter?
Mr. Chairman?
Commissioner Hall?
I agree with you. In fact, I can recall I questioned some of the comments made by the reviewer as of the appraiser. And at that point in time, I made a suggestion that we please notify reviewers that they are going to be held to a much higher standard than anybody else. And when you review something and you start citing USPAP, please read USPAP to make sure you are correct. Nothing is any more embarrassing than receive a call from somebody saying, hey, what is this? That's not what USPAP says. And yet I got cited because of that. This can be very embarrassing for the commission and for everybody involved in this procedure. So I agree with Mr. Green in that we need to make sure our reviewers understand that when they write something down, they better make daggum sure that's in compliance with USPAP, because we're the people who are going to have to sit here and defend them.
I really feel like a motion regarding a letter to the reviewers would be in order.
I thought Mr. Hall, did you make a motion to do that?
No, I was just making a comment as to the...
I will move that we send a letter to the reviewers, making sure that their professionalism is definitely at its highest level while performing reviews for the state of Tennessee.
Well stated. Is there a second?
Second.
Second by Commissioner Stanifer. Further discussion?
Do you want me to draft and then bring back to you, or you just want me to?
I'll trust I'll trust a conversation between you and the director to develop the verbiage, personally.
Can I amend that motion,
No.
Mr. Chairman?
No, you cannot, because you didn't make it. You didn't second it.
You can, anybody can
But
file
you
an
can.
amendment.
Discuss.
You can discuss. Go ahead and discuss, and we'll see it.
I make a motion to amend, to add that Chairman Green review the final draft before it goes out to make sure it meets his expectations.
All right. So we have a motion, a second, and we have a suggested amendment. Is there further discussion?
So in this case, do I need to say I will agree to add
Is that
that to
friendly
it? Or
amendment?
would I say that I will withdraw my prior motion?
If you agree with it.
You can either accept it as a friendly amendment or vote the amendment up or down.
I would vote we move it up to include that verbiage.
And we have a second. All right. Is there further discussion? Hearing none. All in favor of the motion and the amendment, say aye.
Aye.
Is there any opposed? I am. But the motion still passes. All right. Thank you, gentlemen. Moving along. Oh, I had one other question. I don't know if you'd compromise the integrity, and if you cannot answer this question, that's okay. Who is Cecil McNatt?
I think it's a data,
No, no, I think
it's a
like
data
software
provider.
Okay.
Like
Okay, so it's a consultant.
realty
That's what I'm
rates,
familiar with, but-
that type.
Yeah.
Yeah, it's like a realty rates or those type.
Interesting. Okay. And they process income approaches.
I think that information is incorrect.
Okay.
I believe it was a party involved in the deal.
Don't
Yes.
tell us anymore. We don't want to compromise the case, but I had never heard of Cecil McNatt. All right, moving along. I'm sorry. Next item is number 4. Thank you. Please proceed.
2014005591. This complaint was filed by a consumer and alleged unprofessional conduct on the part of respondent. Complainant stated respondent drove onto her property, got out of his vehicle, and began to take pictures of her guest house. Respondent informed complainant's husband that he was an appraiser and was doing comparables in the area. Complainant's husband informed respondent that it was private property and he didn't want respondent taking pictures of his house. Complainant alleged that respondent left the premises, peeling out of the driveway and shooting off 5 rounds from a 9mm gun. 4 of the 5 shell casings were found. Subsequently, a chase ensued. The local police office got involved, but respondent was not detained. Complainant asked that the commission please take note of this incident. No response to the complaint was given by respondent. This type of complaint matter is outside the jurisdiction of the Real Estate Appraiser Commission and should be handled in court if complainant wishes to pursue the matter further. As such, counsel recommends this matter be closed and flagged in the event a criminal conviction at a later date is received by the administrative office.
All right, you've heard the legal counsel's recommendation. Is there a motion?
So moved.
Motion by Commissioner Walton. Is there a second?
I'll second.
Second by Commissioner Collinsworth. Is there discussion? Hearing none, all in favor say aye.
Aye.
Any opposed? None opposed. Item number 5, please.
Item number 5, 2014005631. This complaint was filed by a national bank and alleged that respondent acted in a misleading manner by signing an appraisal for a property which he did not inspect. Complainant alleged that respondent submitted an appraisal on December 10th, 2012, which he signed as the inspecting appraiser. He also made specific statements in the report about inspecting the property and naming a trainee appraiser as providing significant appraisal assistance. The appraisal was disputed. Wagner admitted that he could not respond to the questions as he did not inspect the property. Rather, he sent the trainee to complete the inspection in order to get the appraisal started because he was having health problems and could not make the appointment. Health problems persisted and the appraisal was due, so he submitted the report without inspecting the property. The trainee did not sign the report and was only named as providing assistance. The respondent signed the report as the inspecting appraiser. Since that time, I apologize that name is in there. That is my fault. I didn't realize that happened. This must be an incorrect copy. I don't know if your alls have that or not, but
We do not have a
I don't have a
name.
name.
Okay, good, because mine does, and I was like, shoot. 'cause
Oh, this is
sometimes-
sanitized,
Okay.
not a problem.
Since that time, respondent has retired and made his license inactive with the state of Tennessee. Respondent's license had been inactive since December 2013. Respondent did not provide the state with a response to the complaint, but did make his license inactive effective December 2013. The USPAP ethics rule states that an appraiser must affix or authorize the use of his or her signature to certify recognition and acceptance of his or her USPAP responsibilities in an appraisal review, or appraisal consulting assignment. As respondent has admitted to the behavior described above and has already placed his license into inactive status, counsel recommends that respondent's certified residential credential be voluntarily surrendered to take effect immediately upon execution of the consent order. Such terms are to be settled by consent order or formal hearing.
All right, is there a motion?
I'll make a motion to accept council's recommendation.
Motion to accept by Commissioner Hall. Is there a second?
Second.
Second by Commissioner Stanifer. Any discussion? Hearing none, all in favor say aye.
Aye.
Any opposed? None opposed, motion passes. Item number 6, please.
Item number 6, 2014-005741. This complaint was filed by a consumer and alleged the appraisal report was incorrect because it showed the incorrect owner of public record. She was contacted several times to correct this error. However, respondent continuously sent the same incorrect report. Respondent sent a response to the complaint stating that she had been harassed by the AMC involved in this matter since March of 2014. Respondent stated they are verbally asking her to change the owner of record to the current owner, not the owner of record on the effective date of the report. The respondent provided copies of the public record indicating owner of record at the time of the appraisal. They asked that the owner of record be changed to a person who did not own the property at the time respondent inspected it. Council recommends this matter be closed with no further action. This matter seems to be a dispute between an AMC and an appraiser that the commission does not exercise authority over. There is insufficient information to warrant any type of disciplinary action.
I move we accept council's recommendation.
Second.
Motion by Commissioner Collinsworth, second by Commissioner Hall. Any discussion? Hearing none, all in favor say aye.
Aye.
Any opposed? None opposed, motion passes. Item number 7.
Item number 7, 2014-005981. This complaint was filed by the respondent in the previous matter and alleged the AMC verbally asked her to change the owner of record in the appraisal report, and that the AMC had been harassing her to do so since March 2014. The respondent provided copies of the public record indicating owner of record at the time of the appraisal. Respondent sent a response to the complaint stating the respondent's claim of harassment is false and frivolous. Respondent stated that despite complainant's allegations, it puts its requests and communications to respondent in writing. However, respondent does not respond to emails or phone calls. Respondent stated it is not asking the complainant to change the actual owner of public record, but to comment in the addendum about the owner change. Respondent stated it supplied respondent with the quitclaim deed, and it does not take compliance lightly and would not do anything to jeopardize its reputation. Council recommends this matter be closed with no further action, as it seems to be a dispute between an AMC and an appraiser that the commission does not exercise authority over. There's insufficient information to warrant any type of disciplinary action.
So move.
I'll second.
Motion by Commissioner Hall, second by Commissioner Collinsworth. Any discussion? Hearing none, all in favor say aye.
Aye.
Any opposed? None opposed, motion passes. Item number 8, please.
Number 8, 2014-003201. This complaint was filed by a consumer and alleged respondent's performance lacked professionalism and her professional conduct was unacceptable. Complainant stated that respondent's incorrect property values and definition of living space almost resulted in the buyers being forced to pay a higher interest rate on the life of the loan to compensate her undervaluing of the property. Respondent stated in the response to the complaint that she was not retained by the complainant and had no contact with him other than the inspection, which was routine with no issues raised by him during the same. Respondent also stated that the subject property is located in a rural area with limited closed sales. The closed sales selected were the best comparable to the subject. Although the ideal would have been to have homes that were exactly like the subject, this is rarely a reality. The reviewer's conclusions are listed there if you need to take a minute to review those, and then we'll have the recommendation.
Yes, please give us a minute for the commission to review those reviewers' findings. All right, if the commission's familiar with the reviewers' findings, please proceed.
Council recommends this matter be closed with a letter of instruction pertaining to summarizing information to support opinions and conclusions and reconciling value indications within the appraisal report and the certification requirements of the appraisal.
Thank you. Is there discussion or a motion?
Make a motion to accept council's recommendation.
I have a motion to accept by Commissioner Hall. Is there a second? Second by Commissioner Stanifer. Is there discussion? There is. Commissioner Johnstone.
This is more of a statement than discussion, but in looking at the disciplinary history, it looks as if this person's was quite active in the legal department in '08 and '09. And apparently the first one was not a non-issue, it was dismissed. But then we had a consent order in education, closely followed by a letter of caution. So do we take that into consideration when we look at these? Does the council take that into consideration?
Yeah, and it's really up to you. I mean, the disciplinary history is just listed there in case you want to take it into consideration.
Okay. Go ahead, Commissioner Walton.
I'd like to say this does sound a little bit more serious to me than a letter of instruction. If there is evidence that they truly did not measure the house, I mean, that's what your peers would do in this situation. So technically you've got a pretty serious violation here potentially. Not sure how I feel about, what potential discipline should be meted out, but I think it should be more than a letter of instruction, especially given the disciplinary history.
Okay, thank you. Thank you, Commissioner Walton. I'll weigh in briefly too. I have the same feeling. I think the first bullet point is a fairly significant ethics issue violation. I count 2 USPAP and 2 report writing. So I'm not sure. It would be my feeling that something beyond letter of instructions in order. A class or 2 classes is my thinking. Report writing being one of them, and probably USPAP being the other one. But that's my feeling. Any other comments from commissioners? Commissioner Johnstone?
When you're talking about report writing, you're talking about residential report writing. Would residential procedures be more in order, considering they didn't understand how to measure the home or properly make adjustments? Maybe a refresher on that?
Well,
I'm just-
is there a difference? Is there a residential report
There-
writing?
There is.
There
There's
is.
a residential report writing, and a commercial report writing is much longer course. 15 hours for residential and 30 for,
Does that course deal with any of the procedures, or is it just strictly writing a URAR?
it's not strictly a URAR, but it is a report. Its focus is very specifically on writing reports. There's some discussion on how to elaborate comments for each section of an analysis, like highest and best use, and says comparison, and the different conclusions, how to make sure that you're explaining enough. But it could be a narrative appraisal report. It doesn't have to be a form. They don't distinguish in the class.
Does seem more like a procedures and ethics to me.
I would agree. Yes, I would agree. So maybe one procedures course would get it and sufficiently address the gravity of the errors. And, well, there's not a motion yet. We have a motion on the table and we're still in discussion. The motion was to accept council's recommendation, and that was the second, and we're still in discussion. Is there further discussion?
Is there a residential procedures course?
Just strictly.
There is no, okay. I didn't know if there was maybe a 15-hour or something that a school had put together that is strictly targeted residential.
There's case study courses, case study application and case study courses that are more specifically designed for each of the courses, but that's a higher level course. USPAP, procedures and principles are core courses that everyone has to take. Same thing with statistics. There's another one too, I just can't call it to mind.
Would that be more appropriate, a case studies in residential?
Yeah, I think so. I mean, obviously they're familiar with procedures if they've been licensed for this long. So
Choose to
possibly
ignore them.
an in-depth case study would drive the point home.
Okay, well, in view of the discussion, would the motioner like to withdraw it?
I'll withdraw.
Okay, then the second? Okay, motion and the second are withdrawn. How about a new motion, please?
I'll make the motion that the respondent be required to take a residential case studies course as well as a 15-hour USPAP.
Okay, all right, the motion is for a residential case studies course and a 15-hour USPAP course. Is there a second?
I'll second that.
Second from Commissioner Collinsworth. The motion was by Commissioner Walton. Is there further discussion? Hearing none, all in favor say aye.
Aye.
Any opposed? None are opposed, motion carries.
And I'd like to make a quick announcement. It didn't have anything to do with the discipline, but again, from the review standpoint, there's no date in here as to what the appraisal was, the effective date of the report or the day of the report. However, I see numerous references in here to SR 22B and then additional numbers. Again, we want to make sure if this report had an effective date after January 1st of 2014, that would be SR 22A going forward. So again, we want to make sure that our reviewers are familiar with USPAP. I think this letter that's going out is going out to all of the reviewers, if I remember correctly. Okay.
Thank you. Very good. All right, moving along, item number 9, please.
Item number 9, 2014003221. This complaint was filed by a consumer and alleged the undervaluing of a residential property by using inappropriate comparable sales data. Complainant alleged that respondent used properties in neighborhoods that were vastly different from where the subject property is located and thus undervalued the subject property. Respondent sent a response to the complaint stating that complainant's allegation was not a USPAP violation. Respondent stated that under Standard Rule 1-4, he did his due diligence in selecting the comparable sales, and in his opinion, the sales included were considered to be the most similar available when compared to the subject. Reviewers' conclusions are listed there, as well as the respondent's response to those conclusions. If you guys want to take a minute to look over that, and then let me know when you're ready for the recommendation.
Thank you. All right, if commissioners are done, then please proceed with the recommendation.
Council recommends that this matter be closed with a letter of instruction pertaining to summarizing information to support opinions and conclusions within the appraisal report.
Okay, thank you, Ms. Gamber. Let's have discussion on this first. Would anyone like to start?
Well, Mr. Chairman?
Oh, I'm sorry. Go ahead, Commissioner Johnstone.
I mean, I thought the respondent's response was appropriate. I mean, to the reviewer's questions. I don't know. In this one, I mean, I think that possibly just dismissal, I could live with that in looking at it. It's just my thoughts.
Anyone else? Any other comments?
I feel I agree with Commissioner Johnson. I think it could go either way. I think he's got the point about doing a little more discussion of his site development, and especially, you know, if there in fact were land sales in the work file.
Thank you. Thank you.
I agree with Commissioner Johnston.
I'll weigh in. I feel the same way. I think there's no need for a letter of instruction. I would vote for dismissal. Is there any other comments? Hearing none. Is there a motion?
Move to dismiss.
All right. Is there a second?
Second.
Okay, a motion to dismiss by Commissioner Johnstone, a second by Commissioner Collinsworth.
Chairman?
Commissioner Hall has a comment or a discussion point.
No, I know once again, we talked before about the review appraisers, making sure they know they're correct before they write it down. One of the things was there's no statement in certification. It's not performed. The respondent says it's in that twice. I don't know who's right, who's wrong. But once again, we're back to that same point. If you're going to write right before you do it. The second thing, there's no paired sales. I'm sorry, folks. I would be afraid to bet you more than I ever had in my life, which is $2, that there's not many appraisers in this country, in this world, who has the paired sales for every adjustments ever made in their files. I think that's a little bit.
Point well taken. All right. Any other discussion about the motion on the table, which is to dismiss? Hearing none, all in favor say aye.
Aye.
Any opposed? None opposed. Motion passes. All right.
Mayor, can we have a 5-minute break?
Yes, ma'am. We'll adjourn for 5 minutes. I guess we're not adjourning, are we?
You need to head out, that's fine. To go.
All right, this meeting will come to order. This is a continuation of the May 12th meeting of the Tennessee Real Estate Appraiser Commission. And we are at the point in our agenda where we are to hear a report from our Tennessee legal representatives. And so please introduce yourself and state what your presentation is.
I will. Chairman Green, Commissioners, thank you for having me before you again. My name is Damon Romano. I work with the legal department. I'm a recent graduate of Belmont University College of Law. A few months ago, you invited me to speak before you on the Sunshine Law, a concern that really belonged to your board counsel. Excuse me. Today, I'm here to speak with you a little bit about something that is of more concern to the state litigating attorneys. So when you all make a decision to either take discipline against somebody's license or revoke the license or something of that nature, and they don't like it and they sue you, and that leads to a contested case hearing, it's then the litigating attorney that comes in and argues the state's position, defends your position in front of the administrative law judge. Excuse me. So we're here to talk about that. At the beginning, I've had several questions about how long this is going to take. The answer is that comparable presentations in similar conference rooms in the last 6 months have taken anywhere between 45 minutes and 3 days. So we'll try to get you out. I know that I am the last item on your agenda today, and like you, I have not eaten lunch, and I appreciate you, Chairman Green, for letting me raid your potato chip bag before we got started this afternoon. All right, we're talking about ex parte communications in contested case hearings. What I'm going to do is present it to you not in lockstep as I did last time, but I'd like to present to you in the form of a sort of extended hypothetical problem, because I just got out of law school and that's how we do it. And I hope it'll make sense as we go along. Understanding that you all are eager to get back on the road, I nevertheless invite and welcome questions. If you have any confusion or concern, just stop me and ask, and I'll answer it as well as I can. And if not, I'll punt. All right. The first problem is this. The respondent or the respondent's lawyer has direct communication with a commissioner away from an open meeting, disclosing the existence of a complaint against the respondent and disclosing matters involving the complaint. This, in plain English, is when somebody gets in touch with one of you, however they do, and say, gosh, Mr. Commissioner, Ms. Commissioner, somebody has filed this complaint against me. This is clearly baloney. What are you going to do to help me out with this? Or, in a more friendly tone, we've known each other for 10 or 15 or 30 years in this. That's sort of at the center of this problem. The Tennessee Code says this: unless required for the disposition of ex parte matters specifically authorized by statute, there are a couple of ex parte type of communications that, ex parte means out of the presence of all parties. Okay. So if you're talking just with one party to the litigation, and usually that in your case is going to be the respondent, excuse me, an administrative judge or hearing officer or an agency member, that's y'all, serving in a contested case proceeding may not communicate directly or indirectly, in other words, through a third person, through your executive director, for example, regarding any issue in the proceeding while the proceeding is pending with any person without notice and opportunity for all parties to participate in that communication. Excuse me. So this, again, sort of like the Sunshine Law that I spoke with you about earlier, we're talking about behind closed doors communication with just one party to one of your contested cases. Either you speak with them directly or you have an intermediary or a go-between do it, and it is not. We talk here about while the proceeding is pending. we intend to pick up before the proceeding as well, or the courts will tell us that. Okay, so if somebody calls you and says, Mr. Commissioner, somebody's filed a complaint against me, and we're not yet at the point of getting on to the legal report, we're not yet at the point of a formal hearing, we're still going to get picked up into this ex parte communication prohibition. The next part of the law says this: unless required for the disposition of ex parte matters specifically authorized by statute. Well, did that work? Okay. In connection with any issue in that proceeding, while the proceeding is pending, with any person serving as an administrative judge, hearing officer, or agency member without notice to all parties. So in other words, not only can you not communicate, or you prohibited from communicating with the parties, the respondents, you're also prohibited from communicating with anybody serving, for example, the administrative law judge, and with each other outside of that hearing. It says you can't communicate directly or indirectly with any person serving as a agency member, which again is you all. So this again will kind of reference back to that sunshine law prohibition that I talked to you all about a few months ago, where we said that kind of inter-commissioner crosstalk between you about business matters of the commission pending before you at that time, that's ixnay, right? That's not kosher, because we want to have all of that on the record under the gavel for the public to see who is speaking how, who is voting how. Here then, in the context of a contested case hearing or a formal hearing, we want to make sure that we avoid that crosstalk from one commissioner to another, excuse me, about the matters related to that case. If before serving as a judge, hearing officer, or agency member, a person receives an ex parte communication of a type that may not be properly received while serving. So if somebody sends you a letter or an email or a fax or a text message that says, somebody's filed a complaint against me, you're my friend, we've known each other forever, do something about this, then you are required to disclose that communication. And you're required to disclose it on the record under the gavel in a properly noticed meeting, again, for the protection of the public and for the protection of the state in keeping the integrity of the commission. This one is bigger, so it's in smaller font, and I apologize about that. An administrative judge, hearing officer, or agency member who does receive an ex parte communication that's in violation of this section, which is all of them, shall place on the record of the pending matter all written communications received, all written responses to the communications, and a memorandum stating the substance of oral communications received, and so on and so on. Any party desiring to rebut the ex parte communication shall be allowed to do so. So what this means is that if somebody sends you an email or a text or a fax that constitutes an ex parte communication, you're required to disclose it. You're required to submit the writing of what was sent to you by these people. And if you responded, which is of dubious, required to put that in there as well, and then you want to write a little cover letter that says, this is what happened here, okay? We mentioned before in the Sunshine Law presentation that, gosh, this adds potentially a huge amount of bureaucratic malarkey, that's the technical legal phrase, and it slows down our business and it prevents us from doing what we need to do. Two responses to that. First, you know by now, because I beat it to death the last time I was before you, that the state legislature and the courts of Tennessee are very clear that having everything above board and on the level is much more important to them than efficiency. Secondly, if you think it's going to cause you a lot of trouble, then that ought to be a big incentive for you to do your very best to not be in receipt of these kind of ex parte communications, and then the whole problem is avoided. Commission member, this is the second sort of hypothetical problem. The commission member has phoned the commission's administrative staff several times, has referred to the respondent's case by name, by the respondent's name, and has asked what the respondent's case was that was coming up for formal hearing. Why is this a problem? Folks, it's only a problem if you already know the name of the respondent. And since the legal report is presented entirely anonymously, the only way that you could know the name of the respondent is if you had been in receipt of ex parte communication. If you were hearing stuff that you are not supposed to be hearing or seeing before the fact, and so that's going to raise this giant red flag, and it's going to make it very difficult for the state to defend your actions later when the litigating attorneys come in. Let me then talk a little bit more and develop a little bit more that idea of anonymity. It protects the respondent from negative bias as well. It also protects, excuse me, it protects the respondent from negative bias that might come from a commissioner, and it protects the commissioner from accusations of bias that would then lead to recusal. Now, we'll talk about recusal more in a few minutes, but the bottom line is that, look, if you have, what's required is that if you receive ex parte communication of any kind, you've got to get it on the record. Excuse me. And then the second question is, okay, you've received this ex parte communication, you've been a party to this conversation off the record with the respondent. The second question then is, knowing what you know, can you continue to hear the case and serve as a jury in that case without bias? Only you can answer that question, and so under the law, only you individually have the power to recuse yourselves. Okay, and so you might say, I'm in receipt of this information, I can't unsee it, I can't unhear it, and I don't think I can fairly decide the case on that basis, I have to recuse myself. Okay, but there's no snitch rule, right? So Commissioner Johnston can't go to Chairman Green and say, I heard Commissioner Hall out in the hallway talking to the respondent during a recess, and I need to have Commissioner Hall recused. You can't do that. Only each of you can make the decision to recuse yourself. However, if you choose to recuse yourself, you could wind up in a position to where if more than one of you does it, you're without a quorum. Now you can't make a decision or a ruling on the case. It can lead to other evidentiary problems. If you say, well, I've been involved in this, but I still fairly believe I can fairly decide the case, then what about other evidence that comes in? What if the respondent sent you documents or forms that were filled out or things that later are going to come in as evidence in the contested case hearing? Now that's very muddy as to whether or not that comes in. So if in trying to help somebody, you become a party to these ex parte communications, you could find yourself, in fact, hurting the party that you're trying to help. 304, Section 304 in ex parte communications says it only deals with the requirements after the contested case hearing has commenced. I mentioned before that we are concerned as counsel with both ex parte communications that take place during the hearing and those that are initiated beforehand, because really those that are started before the contested case hearing are the harder to catch, the harder to deal with, excuse me, and the more damaging. I mentioned the idea that our legal report is always very anonymous. There is nothing in the statute that requires that degree of anonymity. It's not a matter of law that we do it that way. It's a matter of departmental policy. But there are good reasons for it, and the reason is because it protects everybody. It protects your licensees from bias. It protects you from an appearance of prejudice, excuse me, and again helps maintain the appearance of integrity and propriety to the public. Of course, it protects the public, and it protects the state. And by the state there, I mean you all make a decision, somebody sues you over it, the administrative law judge comes in, and we have a contested case, and the state's litigating attorney comes in to defend your actions. But if you've been having ex parte communications with the parties outside of the hearing or prior to the hearing, then it prejudices or could potentially prejudice the state. In other words, it makes it a lot harder for them to make their case, excuse me, fundamentally unfair. So they don't rise to the level of violations of the code, but they raise a big red flag. And again, they give that appearance of impropriety. All right, third problem. The respondent or the respondent's lawyer make the same type of contact with one of you commissioners or more than one as in my first example. However, the communication's not made during an open meeting. It might be on the day when you're here, but it's made, as I briefly mentioned a minute ago, in the hallways, in the restrooms, over a lunch break, during a recess of another kind. That's a massive problem. And this, ladies and gentlemen, really goes to the heart of why I'm standing here before you today. This is something that, very frankly, is running rampant. And it's a problem in some commissions more than others. I'm not trying to call anybody out, but there are those professions in which the culture is, look, we all know each other, we all work together, we all went to school together, and it's a very tight-knit kind of a community. And that gives rise to the kind of relationships that as professionals we love. And we enjoy having those kinds of working relationships with the people in our profession. But then when we get elevated to serve on this commission, and then our professional friends want to call us up and say, somebody's complained against me, this is baloney, what can you do to help me out? That's where it's very tempting for us, or for you rather, as commissioners, to kind of break down that barrier and say, okay, let's have a conversation about it. Excuse me. And then, you know, we're in the middle of a case here, and you all are at lunch and are having conversations. And then you come back in, and not all parties have been involved in those conversations. Now suddenly, you've heard things that couldn't help but influence you. The whole point of those communications is to try and influence you. Excuse me. So that's a problem. This type is much more serious, as I mentioned. It is almost certainly a violation of the ex parte communication law. And here's the trick. Again, I mentioned you could very easily end up hurting the person that you're trying to help or that's trying to get help from you. It's a violation for the respondent to initiate ex parte communication with any one of you without the other parties being present. This 45304C carries some minor criminal penalties with it. Okay? So the worst thing that can happen to you as a commissioner is that you divulge your ex parte communication, you get it on the record, and then you make the decision to recuse yourself. That's it. But to the respondent, it could have much more serious and lasting effects. So this part of the law is designed to prevent respondents from trying to initiate this sort of forbidden communication in the first place. We said only you can recuse yourself. There's no snitch rule. You can't force each other to recuse. The administrative law judge, there is some question outstanding as to whether an administrative law judge sitting over here could force you to recuse yourself, but probably not. That commissioner, that hypothetical commissioner that I mentioned in my first two hypothetical problems, let's further assume that that person has talked to the executive director, that one of the attorneys for the respondent in an upcoming formal hearing had previously retained one and possibly other commission members in an eminent domain case. Excuse me, this was not a case before you all, I promise. That's a problem. If you've got a respondent that's going on a formal case, contact Ms. Avers and says, hey, I feel like I'm biased because one or more of the commissioners has previously worked for me or has been hired by me to serve as an expert witness. And I didn't like their testimony, and maybe we became not friends anymore over it. Or I was involved in a hearing as a respondent, I was involved in a hearing with another licensee, with another, say, appraiser. And that other guy hired several of the commissioners as an expert witness in a civil court case outside of this building. Now I feel like I'm being biased because they've worked for people, they've testified against me in court. I believe that I could be walking into a kangaroo court in favor of the respondent or against the respondent. And that the communications with that member might still be in communication with the respondent. This is particularly dangerous again and deleterious because it's it has a tendency to bias your opinion, even unwittingly, against the state and in favor of the respondent. So there we have it. To the extent that that kind of communication is ex parte, and it is, that type of communication where a respondent or a respondent's lawyer is communicating with the executive director over a pertinent case, excuse me, that would be covered. We are going to pick that up under ex parte communication, and it's going to be not good. So Section 304 of the code deals with ex parte communications. Just a few sections up, 302 is disqualification of officials. And this talks about that recusal that I mentioned a few minutes ago. Somebody can petition, any party, either the state or the respondent, can petition the court, the administrative law judge, to have one of you all recuse yourselves. But again, at the end of the day, the only person who can recuse a commissioner in a formal contested case hearing is that commissioner. Excuse me. So you say, well, gosh, why are we here? It is pretty much what we come down to. You have this ex parte communication. This communication with one but not all parties to one of your contested cases. And we've talked about how bad of an idea that is, but then I keep saying the only penalty for it is you're supposed to disclose it. And on disclosing, then the question is going to be, okay, now knowing what you know and hearing what you've heard from the respondent, do you think you're going to fairly be able to decide the case against that respondent? And if you say no, then yes, then you continue sitting, you make your decision, you move on with your life. Why am I then wasting your time and keeping you from getting back home and keeping myself from getting lunch? There are real consequences here, folks. There is no hammer in the law. You know, with the Sunshine Law, before I came to you and I said, look, if you violate the Sunshine Law, all manner of horrible things could happen to you. Here, that's not the case. It's very much sort of an honor code as far as you as commissioners are concerned. This kind of gets into the legal weeds a little bit, and I'm not going to spend a lot of time on it. There is a concern that when you're in your formal contested case hearing, you've heard all of the evidence, the administrative law judge, I don't know where they sit in your hearing room, the administrative law judge gives the case back to you and says, okay, make your deliberations, and you know you have to make those on the record. And you have to come up with your findings of fact, right, and your conclusions of law, and you have to write all those down and issue them forth. Excuse me, and you have a motion and a second is to adopt those or refine them further. While you're hearing the evidence, you're going to make probable cause determinations a lot of times. And that is there probable cause? Is there a sufficient reason to believe that this person did these things? Excuse me. There is a concern among some of the litigating attorneys that some commissions or commissioners will peck too much at the state's attorney or at their own executive director and say, we want more information, you have to give us more. And in a sense, that's a good thing, folks, that the idea that in a contested case you all would be information junkies, that you want to know as much as you possibly can in order to reach a fair decision. We like that instinct. However, for legal reasons, for the protection of all the parties, there are good and sound reasons as to why not everything under the sun is submitted as evidence before you. And sometimes enough is enough. And what we're talking about here is the idea that it's okay to ask for more if you feel like you genuinely need more, but try not to beat your poor executive director to death about it, because a lot of times her hands are tied as well. Sure.
I do know that we have had concerns about this in the past. Is it better to go ahead and charge someone with an offense and deal out fines, educational, and not have all the information available? Is this not creating additional burden on the accused to defend something that maybe does not need to be defended if we knew all the facts involved?
Yeah, I think I appreciate your question, Mr. Hall. Our system, of our legal system, and even your contested case system here, adversarial system. The two parties are opposed to one another, and so it's in the state's best interest and in the respondent's best interest to get as much information out as we can. But for legal reasons, which, without trying to send you through the last 3 years of hell they call law school, I'd rather not repeat for you, there are very good reasons why some evidence just doesn't come before you. Just like in a murder trial, there are some times when there's really good reasons to not have the smoking gun be submitted as evidence, because sometimes that evidence is unfairly prejudicial against both parties. So the knowledge that you might get out of it is less valuable than the damage that it would cause in biasing you or prejudicing you against one party or the other. So that's the first part of my answer. There are good reasons why you sometimes don't get all the information, and why there's an administrative law judge sitting here to make those decisions. That's on him or her. The other part of my answer is that's why we have an appeals process, and if somebody doesn't like a decision, and then we can get the lawyers involved and the chancellors involved. Excuse me. I don't know if that's a satisfactory answer, Commissioner Hall, but that's the answer. Sometimes we just don't get all the information. In the same way, and I hope I'm not being patronizing, it's certainly not my intent, but in the same way sometimes we tell our kids, because I'm and it's not that we don't think that you wouldn't appreciate or understand all the information if you were given it. It's just that we're so concerned that it would bias or prejudice you. But the real problem, since you brought it up, in today's talk, what I'm trying to address is not whether or not you get all the information, right, that you think you'd like to have, presuming it exists. The big problem is one or more of you going out on a fishing expedition on your own to try and dig it up no matter where it is. That's where I would encourage you to fall back on that adversarial process. Understand that these two parties are opposed to one another, and again, it's in both of their best interest to get as much information out that's going to hurt the other side as they can. And so often, you really probably need not go digging for or having these off-the-records communications with one side or another. That's the problem. It's not so much what information you get or don't get, it's how you get it. And if you're getting your information about a case from a respondent off the record, outside of the gavel of the case, then the law is going to say, almost by definition, we're being unfair to one side or the other. And that's where we need to draw the line, step back, and kind of trust the process a little bit. Does that?
I think the question was geared more towards the legal report of probable. Amount of information we can share in a probable cause legal report.
Formal hearing.
And at this point in time, I do not view us as being us versus them. I view us as a body up here trying to get to the facts before we make a decision. I don't want to make a decision and then have to get the state to spend all this money, get the accused spend all that money to find out, if we had told these guys X, we wouldn't be here today. I reckon that's where I'm coming from.
I don't think I've introduced myself. I don't think I've been before you before. My name's Mark Green. I'm Chief thought, and I understand what you're saying, is you want all available information in order to make a determination whether or not this should go. And it's presented as a legal report. The balance that we have to strike when we're doing a legal report is the balance of giving you enough information, and that's on the attorney, and that's a big thing that the attorney has to make a determination. Enough evidence to show that there is probable cause that they committed an act, a violation of the statute, meaning give you enough evidence to make that decision. Not too little and not too much. And as Damon was, I think, alluding to, too much is at the point where you would recognize the case when it comes back for a formal hearing. So you should get all the information that you need in order to make a probable cause determination whether or not this should go to a hearing. And if you don't get that, then that's something that we need to work with the board attorneys about, providing all the information they need to. They have a balancing act because they don't want to give you too much information that you will, oh, I know who that, I know what's going on there. I heard about this case. That's the issue. So when we say we don't give you all the information, that's kind of the thought process. It's not a process of we're going to hide information or hold it back because we don't want you to have it available. The attorney's going to make a determination that if I give them these facts, that in my mind proves or will show at least probable cause. And if I give them more than that, I risk ruining the anonymity and ruining the unbiased nature of it. So that's the thought process.
Thank you, Mr. Green. I appreciate that. However, you have to understand the training that we up here have, and that is to try to uncover every fact we can before we make a decision. If we do not uncover a fact and we make a decision, next thing you know, we're going to be before this board because we made an incorrect decision because we did not have all the information.
Well,
This is our training. This is our background.
And as law school graduates, we have the same training and the same background. And the decision that we have to make is whether or not to give you a piece of information. Commissioner Hall, you were making the efficiency argument, and my counter to that would be this. If we gave you all the facts and all the information on the legal report, and I apologize that I didn't understand your question a minute ago, we'd be here for 9 days every time you had a legal report in order to receive all the information. What Mr. Green is going after is two things. We're also trying to get after some efficiency and not keep you here longer than we need to, give you enough information to make a good call as to whether or not to go forward or not, rather than try the whole thing right off of the legal report without the other party here, without the respondent here. Remember, too, that the board counsel and the litigation attorney, that nobody's trying to snooker you, and they're not in their offices together figuring out how much can we tell Commissioner Hall in order to get him to go along with the way we want him to go along. That's not the way it works. I'll just have to ask you to take my word for that.
Well, and one of the things that I say in response to your very articulate, expression of the fact we want all the facts before we make the decision, and we understand that. The final decision, however, is at the formal hearing. That's when you get all the facts. When you have both parties, you have the state presenting their case, you have the other party rebutting what the state's case is, and then the state has the burden of proving that before you and providing all the information at that point. That's where you get all the information to make the determination as to whether or not this person committed a violation. At the legal report, you're saying, okay, given those facts, there is a probable cause that this person may have committed this, and we're going to authorize a consent order, and we're going to send that out to say, look, based on the evidence the state presented, just like in a grand jury hearing, based on the evidence just the state presented, there seems to be probable cause that you committed this act. Do you want to settle it? This is what we authorized to settle it. And sometimes they'll say, yeah, I want to settle it. I'm not going to have a hearing because I know I did that plus some other stuff. And sometimes they say, no, I'm not settling it. I want a hearing. I want my day before the board. I want to be able to present evidence, and I want to be heard. And then that's when you, as the commission, get to sit down and hear from both sides, get all the evidence in on the record, and then you make your determination as to whether or not we proved our case or whether or not we didn't. Yes, sir.
Thank you for this presentation today. Sometimes, I mean, I've seen this happen at least 2 times, maybe 3 times in a legal report over the last couple of years where we didn't really need a whole lot more information, just maybe one more little tidbit, and you could make, because as it was presented, you just didn't know.
Right.
You just flat out didn't know. But just maybe like one little thing, not talking about a name or an address, just one little thing pertinent to that helps decide whether yes or no to move forward. Is that unreasonable to ask for one small thing?
And that's why during the legal reports, I think you have the right and the duty to ask questions. If a thing, you know, if first echelon of probable cause, but if I knew if there was a report done, you know, before, you know, if A happened before B.
So what you're saying is that's not off, I mean, we can still ask that
Yeah,
kind of
you can,
stuff.
absolutely, you can still ask questions.
Right.
And, you know, and if you feel, I just don't have the information, I need to ask this one more, you know, this would help me if I knew if this happened or that happened. If I knew that, then that would help me make a decision. There's nothing wrong with you asking a question about it, absolutely not. It's when you get into asking questions about, you know, well, what part of the state did this happen in? What did you know? Well, when did you get this complaint? It's information like that we're trying to not just dump every fact on you in order to preserve some anonymity. So, anyway, I'm sorry to jump in. I just wanted to see us.
No, I appreciate that. I misunderstood the question. I appreciate that. So, having beaten that thoroughly to death, so here's the statute that Mr. Green was just referencing, whether you knew it or not. This is the statute you were referencing. A person who has participated in a determination of probable cause, that's y'all, or other equivalent preliminary determination, or has participated in a decision that is on administrative appeal in a contested case, may serve as an agency member in the contested case. There was some confusion a few years ago as to whether the people who heard the legal report could be the same people who heard the case on a formal hearing. And for a long time, people said, no, it can't be the same set of people. And a lot of commissions would set up a sort of a committee or a subcommittee that would hear the legal report and make the determination as to whether or not to issue a consent order or have the contested case hearing or things like that. And then that would go before the full board or some other committee. We're telling you that you can do both, hear the legal report and sit as the jury or the finder of fact once the formal comes. But the fact that we need to have this law ought to tell you how hard we're driving at the idea of anonymity. And as Mr. Green said, you don't want to recognize it on a formal hearing when it comes before you from where you heard it on the legal report before. Those are your laws that cover appraisers. The end. The reason I mentioned that there is because I was looking in the rules and regulations, section 1255, to see if there was anything on ex parte communications or any penalties that would accrue to you for having those kind of communications, and there's not. We're just back again to that school where we live in the sort of honor system for you all to disclose that you've had those communications, and if you feel that you can't fairly decide the case to. Again, I appreciate your time. Thank you for letting me come before you. Any questions?
A quick one, Mr. Romano. I think it would help us to hear once again what the function of a formal hearing versus the legal report is. I think there's still some question in our commissioners' minds about why a legal report and how does it differ from a formal hearing?
I think the answer to your question, Chairman, is more of a procedural one. You know, I mentioned in colloquy with Mr. Hall a few minutes ago this sort of efficiency argument, and you can make that argument. But the idea is we can understand, right, as educated persons fairly quickly that if we tried to give you everything all at once, enough to make a final decision on this person's behavior or what you needed to do to their license or whether or not to send a consent order, if we did that all at once, it'd be drinking like from a fire hose for you all. On the other hand, if we only had contested case hearings and had no legal report, oh gosh, you'd never leave. You'd be permanent state employees because everything would take forever. So part of it is a procedural thing. Commissioner Hall very rightly mentioned that, you know, there's a lot of time and money and expense involved for all parties. And so we don't want to make them get involved in that or make you all get involved in that unless we think that there's enough to go on. But you're the commission, so you guys have to be the ones to determine whether or not. And this is one of the hallmarks of the American justice system, whether it's criminal or civil or regulatory as we are here, this sort of incremental approach. We're going to do as much as we need to do now, but not more. If we need to do more, we'll do a little bit more, and so on and so on.
And Mr. Chairman, just to add to what Damon was articulating, the commission, as the Division of Regulatory Boards, we have an obligation to process and to review all complaints that come in. And obviously some complaints, there's no statutory authority for there to be a complaint. It's just somebody who's upset with another person. Some complaints are clearly there's something going on, there's a violation. And so we have the responsibility to first, the executive director and her staff reviews them, sends them to legal, and then the legal department reviews them in order to prepare the legal report. Because ultimately it's the commission, each of the commissions, not just your commission, but all of the boards and commissions, to make a determination as to whether or not this person should have a formal hearing. Because once a complaint comes in, they have the right to a formal hearing. But we don't want to make everything a formal hearing, because some things we don't have jurisdiction over. Some things are just consumer complaints. Some things are more contractual in nature, not really violations of any specific statute that we govern. And so there would just be no way to give all those people cases formal hearings in which we know there's no legal basis. So the idea is we present an anonymous legal report at the board meetings, at your commission meetings, to say, these are what the complaints that came in. Here are the facts that we believe is pertinent for you to make a determination. And at that time, you get to decide whether or not, yeah, that should probably go to a formal hearing, or no, that should not go to a formal hearing, that should be dismissed, or a letter of warning or something, you know, it doesn't rise to the level we think of a formal hearing. And at that point, you're giving us authorization to contact the respondent and say, the commission heard this matter anonymously, and they have authorized it to go to a formal hearing. Now, a lot of times the respondents believe you have had a formal hearing in their absence, and that is not what has happened. We have just presented anonymously the bare facts, or as little facts as possible, in order to preserve the anonymity, to let the board make a decision as to whether or not they wanted to hear in a formal hearing setting the case. At that point, they have the opportunity to participate. So the legal report is not a hearing at all. It's just a determination of a minimum level to say, let's go to the next level. And at that next level, that's when the respondent can have his day in court before you as the commission. And we recognize that sometimes we have cases where respondents win. I mean, we don't prove our case, but that's how it's supposed to work. You know, we understand we're not supposed to win 100% of them. Sometimes there's good evidence that's presented by the respondent that makes the commission go, there wasn't a violation here. I'm sorry, there's not. Dismiss it. But that means the system works. But that happens at the formal hearing stage, not at the legal report stage, which is just the first report of the facts to the board. So does that answer your question?
It does.
Okay.
It does. I think a lot of us get confused and think that we're passing judgment, and
Right.
we're not.
Right, and a lot of the respondents believe that too. We get a lot of calls, from people, I'm not necessarily this board, but in cases I've been involved in where notice of hearing and charges were filed, respondents calling and saying, well, I didn't even have a chance to come before the board to explain my side. No, you didn't. This is what you are now. This is the formal hearing process. And I understand that that's kind of a tricky thing to try to, especially with people who aren't familiar with regulatory law, which most people aren't. That's kind of a tricky thing to try to explain. But their day in court is the formal hearing.
We weren't privy to this, but we have a new class that we're being required to implement by the feds, and this very content would be excellent for the supervisor trainee class, so that we educate our appraisers better about how this works.
Sure.
Thank you. That's all. Other questions?
I would say, though, that the legal report, when we're looking at whether it's probable cause or not, many times they are dismissed, or they're out of jurisdiction or different things. Those are easy ones, but I would say that, we're quasi passing judgment in the legal report when we say, I think they need to take 2 classes and pay $1,000 consent. That's a plea deal, more or less. And then the appraiser can either take it and say, yep, I did it, I got off lucky, or they can say, hey, I didn't do that, then I want to come back and be heard.
Right.
So-
And if they take the consent order, you call it a plea deal, and
Yeah.
that's not too far off the mark, Commissioner Johnstone. If they take the consent order and pay it, or take the classes, or what have you, that's also proof that the system works.
Right.
They probably got caught for these 2 things.
Yeah.
And in another way, the system works too. If you get something on the legal report and you go, oh, come on, there's nothing here, and you dismiss it, and that person really is a bad actor, they're probably going to be emboldened, and they'll keep on keeping on, and eventually you'll get them. The question is, on the legal
is true.
report, is this enough to raise a red flag for me as a commissioner? Does it pass the smell test? And that's all you're getting after.
I think sometimes, in overall, I think the department does a terrific job in handling these cases and within the system that we've got. I think occasionally the few cases where there is some question, working within the system, as you guys have explained it, could be just a little more explanation of the rationale that went into developing the penalty suggested. Might help us to follow where legal went without getting too much evidentiary discussion in there.
Sure.
So in other words, you would like to hear, I just want to make sure I'm understanding you right, Commissioner, you want to hear violations we credibly believe have occurred, and this is why we're recommending these penalties and not more or less.
Correct.
Okay.
Because I think that's where the discussion falls on this board a lot of times is, well, why was it this and not that?
Yeah, I understand.
But does that usurp the peers, if you will? We are the peers, and shouldn't the peers be dealing with it rather than an attorney who is not an appraiser?
The attorney can give you what the violation, obviously, what their belief of the violation is, and what the range of penalties are for that. You have to make the determination as to whether or not, because remember, this is just an offer. You're not assessing a civil penalty. You're making them an offer to settle. And there's nothing wrong with you saying, okay, if that's a violation of, ABC, then what's the range of penalty for that? Is it $1,000 per? Is it, $1,000 per day? Is it, 0 to 1,000? Can we do 500? I don't think the recommendation from the attorney, and then you're asking what's the range on that. is completely appropriate within your authority.
See, I would disagree with Commissioner Walton. I would almost prefer legal make no recommendation and leave it completely up to the board to assess what, if any, violations and what, if any, the ramifications should be. And then if we need clarification from legal as to what the penalties could range, how much per day, or that sort of thing, that would be my personal opinion. Ms. Avers?
If I may make a comment, the attorney makes a recommendation on the legal report. In the interest of consistency, we try very hard. We don't always get it 100%, but we try very hard to, compare cases that might be similar and go in that direction. The commission always has the authority, and it's not at all irksome to me or Ms. Baird if the commission has a different recommendation because they, I'm sorry, I know you got married.
Ms. Gamber.
Gamber.
Yes.
I haven't quite adjusted to that yet, but it's the commission's decision, and ultimately, if you read the alleged findings or potential violations in a legal report, and you think, "Wow, that sounds really bad," that's what you're for. You're to make the decision ultimately on that within your authority. So as long as you stay within your authority, make any decision you wish on
Okay.
that.
Commissioner Hall?
Two things. Number one, in spite of the obvious perception, I do appreciate you gentlemen coming in and speaking with us.
Oh, I didn't perceive
Very
otherwise,
much.
Mr.
Very
Commissioner.
much. I appreciate Ms. Keeling speaking to us and giving, because I feel like she's got more information than we are being given and what we are being presented. And she has a better feel or handle on what is really going on. So I appreciate her giving us a recommendation, because I feel like we only getting a little bit of the iceberg here. She knows more about that iceberg than I do. And so therefore, I appreciate her taking her time. Do you mind me calling you Miss Keeling? I'm from the South. We always call people Miss, the first name, okay.
She's very good at that.
Anyway, that's my observation.
Commissioner Standifer?
Could you kind of help us, and I think where the disconnect is, or the
Excuse me, Commissioner Standifer, could you speak into your microphone? I think this would be beneficial for everyone to hear.
I'd like to get your thoughts on that process, and we certainly appreciate the job that everybody does, but there seems to be a disconnect or a layer of complication there that sometimes we, as appraisers, we know that there has been a review by an appraiser, and then making a recommendation. Do you have any thoughts, or maybe you could educate us a little bit about how to kind of sort that out? And because we're looking at it from setting here as appraisers, we know there's been a review of that, but we know someone has taken that and they've looked at that and now they're making a recommendation. So I think sometimes that's where we're kind of second guessing ourselves, or maybe wondering if we have everything.
Is it the way I understand it is the reviewer kind of educates the attorney on the issue, because there are, obviously there are some boards that are less complicated than others, and most boards don't have reviewers. There are some that do, and you're one of them, because of the different there's complex matters that aren't our expertise, and it's my understanding that the reviewer kind of explains the matter as far as their opinion to the attorney when they make their recommendation. And Nicole and Keeling, if you want to chime in on this, please do. But based on that information that the reviewer, after they have sat and said, this is what I see in this file, and they have given it's then legal's responsibility to take that information and make sure it comports with what the statute says, whether or not the reviewer's finding of ABC is in their opinion a violation of the code, and then present that to you so that it remains legal's opinion. It's not, the reviewer has educated them, the reviewer has given their comments, kind of explained what's going on, and then based on that information, she sits down and to make a determination if the facts as clarified by the reviewer does indeed fall within a statutory violation, and then presents that. It is not meant for the reviewer to be the decision maker on the matter. It is meant to provide the attorney and the staff with information based upon their expertise. And so that's kind of the best way I can explain it. The legal report is still the responsibility, and the information presented is still the responsibility of the legal department after they have received necessary background information from the reviewer. Do you want to add any to that?
That's accurate.
Okay. Nicole?
Yes, and legal counsel tries not to, on the probable cause thing, to, the reviewers are to review for compliance with USPAT, which you all know, or any other part of our laws or rules. And then they compile a review report and put together what they see as the issues. The board does not have to accept all of them. You can accept A, B, C, and D, or A, B, and D, but not C, or whatever those bullet points issues are. If it doesn't sound like that's a violation, you don't have to accept an item on the legal report as a whole. You can accept it in part and go, okay, I think you have something here, and you probably do with probable cause to proceed to formal hearing, but not with that item, and I don't want to hear that at a formal hearing. So, the board has that discretion. The attorney still may even, before it goes to formal hearing, after they've had the review and they've sat down with the expert and depositions have been taken, they may decide, well, we're going to file notice of hearing and charges, and there's this one item here that was alleged initially, but I don't really think we can prove it. Take it out of the notice of hearing and charges and just summarize the ones we think we can prove. And that may change. Something at the outset isn't necessarily what the final product before the commission is going to be. Certainly we wouldn't go too far astray of what's presented on the legal report, but there has been cases where, certain items, either the commission didn't feel it had probable cause, or the litigation attorney didn't feel like they had enough to prove it, and the state wouldn't want to present a weak case.
Thank you, Ms. Avers. Let's move on. Are there any other questions or comments?
I just want to make one comment, if I can.
Yes, you may.
I may have said this before, but I just want to, clarify. It is difficult. I know that sometimes you guys have issues with the conclusions that the reviewers come up with, and I completely understand that. But from my point of view, when I'm reading the report that the reviewer sends back to me saying, hey, this is what happened, it's difficult for me as a non-appraiser to disagree with them. I really can't, because I'm not an appraiser. I don't understand it that way. So the only thing that I can do is present it to you the way they present it to me, and then have you guys make a decision on that. Because I feel like I'm not in a place to dispute the reviewer, because I don't do what you guys do. So,
and certainly she couldn't present the support contained in the reviews. That she may be summarizing the allegation in the of violation in the review, but the reviewer probably has attachments and exhibits and stuff that may come in as evidence later, but we couldn't present that to you now, in a probable cause, because essentially we would be participating in an ex parte type situation where the respondent hasn't had a chance to object to any exhibits, hasn't had an opportunity to, really it's not a formal hearing. Probable cause is not a formal hearing. So
We
just have-
understand.
we have
Thank
to-
you. Well, and I appreciate your position, Ms. Gamber. We would never want to ask you to weigh in, just as we'd hope you'd never ask us to weigh in on legal matters. So, all right. Well, perhaps we can wrap up. Mr. Romano, thank you. We really appreciate it. Mr. Green, thank you.
Thank you, Mr. Chairman. I appreciate your time.
Well, and it's my pleasure to tell you two gentlemen how much we enjoy working with the professional that Miss Keeling Gamber is. She's a pro. She's really good. She's very personable. She brings it down to our level. She's really super. So
Enjoy working with Ms.
we do
Gamber
too.
also.
I just want you to know. All right.
Thank you.
Thank you. Is there a motion to adjourn?
So moved.
And a second. Motion, all in favor?
Aye.
And none opposed. We're adjourned.